Passable item number 6.
Whatever steps you have taken, as has been mentioned here, there are documentary proof to that effect. Like you have mentioned that the photographs of this accused have been post pasted in railway station, bus stand, etc. You have the clips with you.
Sir.
Now the what is the age of the girl now?
16 plus.
Okay, what she was doing prior to this?
So she was studying in class 10
Hmm.
at the time of her elopement and fled away.
What her parents are doing?
They are delivery laborers, sir.
Okay, and what the boy?
Boy is a was studying also studying ITI,
Hmm.
but actually study was not for his purpose. He belongs to the scheduled caste community.
Hmm.
His intention was to continue studies in order to get the government money received in term of stipend.
Okay.
So he was merrymaking with the stipend money,
Hmm.
never attending the classes.
What would be his age, boy's age?
24, sir.
24.
Sir.
And what his parents?
They are also daily wage labor, very poor people.
They belong to same village or adjacent?
Same village,
Same village.
same locality, same village.
So you are getting no clue even after examining the parents or in the relatives of the.
Both parents have been put under, sorry, parents and suspected persons were put under polygraph test also,
Mhm.
but no result came out because their involvement could not be made out.
Mhm.
Because the father of the father of the accused, have married another lady after death of his original mother.
Mhm.
So the boy is maintaining a strange relationship.
Since when the marriage?
Marriage,
It's the second marriage of the.
second marriage, 11 years
Okay.
now. The boy was not coming to the house. He was roaming here and there in a vagabond way.
How he was maintaining himself?
He was getting the stipend money from government.
Mm.
As well as he was an occasional singer in the band parties. During marriage seasons, he used to sing in the band parties and get 1,000 rupees per day for singing session.
Mhm.
So within that money, he was maintaining his livelihood.
This have you got some clue that they were in love, both of?
Yes, sir.
Okay.
Everybody knows that in that locality, everybody knows about their love relationship.
Okay.
The um, boy used to visit the girl's house regularly,
Hmm.
gives money to the girl, money and other chocolate bagara.
Mm.
He used to give in front of others.
Mm.
Local people, they have also intimated the fact of their love relationship to the mother of the girl, but she did not believe and allowed the boy to visit her house as he was visiting earlier.
Okay.
So
So
taking that
no,
opportunity,
they left the village in any vehicle, or just in the routine manner, bus or train, whatever. That
sir, what
in
I got
any kind.
information later that they moved away from the village by a vehicle. Later on, they to Sambalpur, and from Sambalpur to they boarded a train to some
Okay.
undescribed destination. Sir. Later, I got some information that he was working in some as a security guard in Sambalpur.
Mm.
We searched all documents of security agencies, but
Mm.
did not find the major security employer is Mahanadi Coalfield Limited
That
MCL.
band party owner is not supplying any a kind of financial assistance to the
Sir,
boy.
I have contacted band party owners with whom he was affiliated before playing away.
Yeah.
The band party owners told that he has taken advance money from all band party people
Okay.
in order to work with them.
Very much charging.
So after that they fled away. They are also searching him to realize their
Okay.
given money.
And the girl even is not keeping any contact with her friends also.
No, sir. Girl was in contact with the boy
Hmm.
through a mobile, through the
Hmm.
mobile of her mother.
Hmm.
Before fleeing away, she has deleted all data from the mobile.
Hmm.
So we are unable to retrieve the data
Hmm.
because the phone has been formatted.
Okay. Okay. So you carry out your investigation. We are adjourning this matter. Uh, is Mr. No, anybody present from the petitioner side is not there.
Mr. Patnaik was there on Monday.
Okay. Today nobody appears, so none appears like them. Mr. Ravi Narayan Padi, DSP, CAW and CW Bhubaneswar is present. He has filed a status report in connection with CAW and CW PS case number 3 of 2022 under section 363 of the Indian Penal Code, in which various steps taken for tracing out for rescue of the victim girl and for arrest of the accused involved in the case has been highlighted. The report is taken on record. The you are investigating the
Sir.
LDA.
Initially, it was investigated by the local police station. After 3 months, after about 3 months,
The investigating who is also the investigating officer. The investigating officer has sought for some further time after hearing the Grand Council for the states, also the IO, and after going through the status report, we feel it proper to grant some more time to the investigating officer to carry forward his investigation and to rescue the victim girl and to arrest the accused persons involved in the case. Put up this matter in keep it on March. So that would be commencing from 4th March 2020. 4th March 2024. Personal appearance of the IO is dispensed with. Free copy of the order be handed over to the Lion Council for the state. Okay, what
Item 16.
May I please, Your Lordship? The appellant convicted for the offense under section 302 IPC may Lord, directed to RI for life and fine of rupees 5,000 in default RI for 6 months, my lord. Beg your pardon, my lord. I am appearing on behalf of the Rehna Khatun, my lord. Because of some difficulty, I am appearing on behalf of her.
No, it's a jail criminal appeal. It has Mr. Khatun has been engaged by the
Yes,
legal
my lord.
services authority.
Because of her some difficulty,
No,
she has
for that
handed over to me.
you are to be engaged, and then you can argue the matter. Not that you can start the matter as such. It is not a private brief. So that is it a private brief?
No, my lord.
So
She had handed over to on your behalf to submit, my
she
lord.
cannot. She cannot.
My lord.
It's a uh, legal aid services authority has entrusted Khatun to argue the matter. If she has the problem, she has to intimate to the authority so that they can engage anybody.
My lord.
Otherwise,
I will
the court
intimate
can
her.
engage. Okay.
My lord.
So you are prepared in this
My
case.
lord.
What is your years of practice?
My years of practice, my lord, I am 98 since 98.
Okay. So uh, please write your name. We are engaging you, and we will not take up this because the order will be passed today. We'll take up the matter next week
My lord.
because so that take the name. The order टा केबे ହେଇଥିଲା ରେନା ଖାତୁନଙ୍କର ଦେଖିଲ ଜାଣ ହେଇଛି 27/6/2023 ହଁ 27/6/2023
My lord. Idi to be. Idi to be.
ପ୍ଲିଜ ଆଣନ୍ତୁ ସେ ଡକୁମେଣ୍ଟ ଆଣନ୍ତୁ
ନାଇଁ ନାଇଁ ଅର୍ଡର ସିଟ୍ ତଳଟା ଦିଅନ୍ତୁ ଅର୍ଡର ସିଟ୍ର ତଳଟା
Legal aid services authority ଗୋଟେ ଲେଖିଥିବେ ତାଙ୍କୁ ଏଣ୍ଟ୍ରଷ୍ଟ କରିଥିବେ ନା
ଅର୍ଡରରେ ସାର୍ ନାଁଟା ନାହିଁ ସେ ଯୋଉ ସେମାନେ ଦେଇଛନ୍ତି
ଉପରେ ପୁରା ଅଛି ଟୁ ରେନା ଖାତୁନ ବୋଲି ଦେଇଛନ୍ତି ଏନଗେଜ କରିଛନ୍ତି
ହଁ
as per order number so and so in JCRL number 108 ଠିକ ଅଛି ତ ଲେଖନ୍ତୁ as per the order dated 27/6/2023 order number 8 dated 27/6/2023 uh, Srimati Rehna Khatun was engaged to argue the matter on behalf of the appellant by High Court Legal Services Committee as per later dated 7/8/2023. She has some personal difficulty.
yes
It is stated at the bar that on account of personal difficulty, Srimati Rehna Khatun is not in a position to argue this criminal appeal. Here, ଆପଣଙ୍କର ନାଁ ଦେଲେ Susmita Nanda, Land Counsel for the Land Counsel who is present in court and having 25 years of practice. is engaged as amicus curiae to argue the appeal. She submitted that she has been handed over. That has been handed over to you by Rehna. Srimati Rehna Khatun has handed over the paperwork to her. Put up this matter in the week commencing from 22nd January 2024, indicating the name of Sushmita Nanda in the cause list. The number is item number 16. The names of Mr. Sujit Kumar Gupta and Rehna Khatun shall not be reflected in the cause list henceforth. It of the
Item 17.
Yes. So who is to argue? You are to
My lord. Conviction under section 302 of my lord.
Yes, yes.
Kindly have a glance to the FIR, my lord, at page 23.
Mr. Tripathi will argue this.
Man.
What is the page number?
Page 23 of the brief, my lord.
Yes.
ମୁଁ ଶ୍ରୀମତୀ ଜନ ନାୟକ ପିତାବଦ ନାୟକ
Jana Naik is PW.
PW1 my lord informant
Please continue.
ରେଙ୍ଗାଲି ଆଲି ଥାନିଆରେ ରିୟାମଲ ଦେବଗଡ଼ ଆଜି ତାରିଖ 20/5/2003
No, no. Who is Guruvari Naik?
Guruvari Naik is
PW2,
PW2
my lord,
mother of the informant.
mother of the informant, mother-in-law of the accused.
Yes.
It's PW2.
My lord.
Yes.
ଅପରାହ୍ନ 4ଟା ଘଣ୍ଟା ସମୟରେ ମୋର ମା ଶ୍ରୀମତୀ ଗୁରୁବାରୀ ନାୟକ ସହିତ ହାଜର ହୋଇ ଏଇ ରିପୋର୍ଟ କରୁଅଛି କି ଗତ ବର୍ଷ ଜ୍ୟେଷ୍ଠ ମାସରେ ମୋତେ ନନ୍ଦ ଆଦା ପିତା
Is the appellant.
ଆଜ୍ଞା ନନ୍ଦ ଆଦା is the appellant. He is the appellant. ବାସୁଦେବ ନେଉଳପାଳ ନାକଟି ଦେଉଳ ଜିଲ୍ଲା ସମ୍ବଲପୁର ତାଙ୍କ ଦ୍ୱିତୀୟ ସ୍ତ୍ରୀ ରୂପେ ବାହା ହେଲେ ନନ୍ଦ ଆଦାଙ୍କ ତରଫରୁ ମୋର ଗୋଟିଏ ଝିଅ ଜନ୍ମ ହୋଇଛି। ସେ ଝିଅର 2 ମାସ ରେବତୀ ଅଡାର ଓ ତାର ବୟସ 1 ମାସ ହେବ।
Rebati is the deceased.
Deceased, my lord. ମୋର ସ୍ୱାମୀଙ୍କ ଘରେ ପାଣି ଅଭାବ ଥିବାରୁ ମୋର ଡେଲିଭରି ପାଇଁ ମୁଁ ବାପା ଘରେ ରେଙ୍ଗାଲି
ରେଙ୍ଗାଲପାଲିକୁ ଆସି ସେଠାରେ
ରହୁଛି। ମୋର ଝିଅ
ମୋ
ଛୁଆ ଜନ୍ମ ହେବା ପରେ ମଧ୍ୟ ମୁଁ ବାପା ଘରେ ରହିଅଛି। ମୋର ସ୍ୱାମୀ ନନ୍ଦ ଆଦା ମଝିରେ ମଝିରେ ମୋ ବାପାଙ୍କୁ ମୋ ପାଖକୁ ଆସନ୍ତି। ଗତ 3-4 ଦିନ ତଳେ ମୋର ସ୍ୱାମୀ ଆସି ମତେ ତାଙ୍କ ଘରକୁ ଯିବା ପାଇଁ ବାଧ୍ୟ କଲେ। ସେଠି ପାଣି ଅଭାବ ଥିବାରୁ ମୁଁ ବର୍ତ୍ତମାନ ତାଙ୍କ ଘରକୁ ଯିବା ପାଇଁ ମନା କଲି। ବର୍ଷା ପାଣି ପଡ଼ିଲେ ଯିବି ବୋଲି କହିଲି। ଏ କଥାରେ ମୋ ସ୍ୱାମୀ ରାଗି ଯାଇ ମୋର ଝିଅକୁ ଜବରଦସ୍ତ ନେବା ପାଇଁ ଟଣା ଚିକା କଲେ। ମୁଁ ଝିଅ ରେବତୀକୁ ମୋ ସ୍ୱାମୀଙ୍କ ଠାରୁ ଜବରଦସ୍ତି ଛଡ଼ାଇ ଆଣିଲି। ଆଜି 25/2023 ସକାଳେ ପ୍ରାୟ 10ଟା ସମୟରେ ମୁଁ ବାରଣ୍ଡାରେ ଭାତ ରାନ୍ଧୁଥିଲି। ମୋର ଝିଅ ରେବତୀ ଘର ଭିତରେ ଶୋଇଥିଲା। ମୋର ସ୍ୱାମୀ ନନ୍ଦ ତାର ଆସି ଝିଅ ଶୋଇଥିବା ଘରକୁ ପଶିଗଲେ। ମୋର ସ୍ୱାମୀ ଘର ଭିତରେ ପଶି ସାରିଲା ପରେ ଝିଅ ରେବତୀ ହଠାତ୍ କାନ୍ଦି ଉଠିଲା। ଝିଅର କାନ୍ଦ ଶବ୍ଦ ଶୁଣି ମୁଁ ରେବତୀ ଦୌଡ଼ି ଗଲି ଓ ଦେଖିଲି ଯେ ମୋର ସ୍ୱାମୀ ଝିଅ ପେଟରେ ଇଞ୍ଜେକ୍ସନ ଦେଇ ସିରିଞ୍ଜ ବାହାର କରୁଛି। ମୋ ଆସିବା ଦେଖି ନନ୍ଦ ଅଦା ଇଞ୍ଜେକ୍ସନ ସିରିଞ୍ଜ ଟାଣି ଆଣି ଘର ପଦାକୁ ପଳେଇଲେ। ଝିଅର ଦେହ କଳା ପଡ଼ିଗଲା ଓ ସେ କାଠି ପଡ଼ି ଝିଅର ଏ ଅବସ୍ଥା ଦେଖି ମୁଁ ପାଟି କଲି। ମୋର ସ୍ୱାମୀ ମାଟିଆକୁ ବିଷ ଆଣି ଇଞ୍ଜେକ୍ସନ ଦେଇ ମୋର ପାଟି ଶୁଣି ମୋ ସ୍ୱାମୀ ଦୌଡ଼ିକି ପଳାଇଗଲେ। ମୁଁ ଏକଥା ଗ୍ରାମବାସୀଙ୍କ ଜଣାଇଲି। ସେମାନେ ସମସ୍ତେ ମତେ କହିଲେ, ଝିଅକୁ ଡାକ୍ତରଖାନାକୁ ନେଇଯାଅ। ଗ୍ରାମବାସୀଙ୍କ ପରାମର୍ଶ କ୍ରମେ ମୁଁ ଝିଅକୁ ଡାକ୍ତରଖାନା ନେବା ବାଟରେ ରେଙ୍ଗାଲି ପାରି ଗାଁ ବିଷ ଇଞ୍ଜେକ୍ସନ ପ୍ରଭାବରେ ମୃତ୍ୟୁ ହେଲେ। ମୋର ରିପୋର୍ଟ ତଦନ୍ତ କରାଯାଉ, ଦୋଷୀଙ୍କୁ ଦଣ୍ଡ କରାଯାଉ।
Come to the C report at page 60.
Yes, my lord. Yes, my lord. Report is against me, my lord.
And then come to the PM report.
I don't have postmortem.
Who is the doctor who conducted PM?
Yes.
PW4.
PW4.
Please place it.
On 21/5/2003, I was Assistant Surgeon, District Headquarter Hospital, Deoghar. On that day, on police requisition, I conducted the postmortem examination on the dead body of the deceased Rebati Ada, daughter of Nanda Ada of village Nuarpali under Nakti Doula, PS, and found as follows. External injury. The body was looking bluish, no ligaments was detected. Tom was prostitute and bluish. Finger and toes were swinished. Face was bluish, hypostasis, and was present on the back. No injury was detected. On recession, all wishes were intact but confessed stomach vampsy. Opinion, my lord. The mode of death was due asphyxia. The cause of death was reserved to be finally opined after chemical examination of the viscera, which was preserved time since death within 20 to 40 hours of postmortem examination. Exhibit 6 is my signature. Shall I go ahead, my lord?
Yes.
Cross-examination of defense. Giving injection to an ordinary person may lead to bleeding or may not. I agree Modi's jurisprudence that asphyxia is the cause of hanging, strangulations, suffocations, throttling, leading to suffocation and drowning. In case of accident, it may lead to death. The possibility of the death of the child while breastfeeding can be ruled out, but it is remote. Injury is a must when there is pick of injection. No series was produced before me for my examination and opinion. I did not notice any sign of injection on the body of the deceased at the time of my postmortem examination.
Continue.
Further examination by the prosecution on recall on 13/9/2003, I received a query from police to opine whether injections pesticides by a syringe will lead to death or not, to which I replied that death in such case is possible. Exhibit 6 is my report and Exhibit 6/1 is my signature. Further cross-examination by the defense. Presence of pesticides in blood can only be ascertained on chemical examination of the blood and viscera, etc.
So that particular as appears at your instance in page number 51. That is the IOS evidence.
Yes, my lord.
Come to 1, 2, 3, 4, 5. 5 lines from the top of page number 51.
On 21/5.
Right. Page number 51.
Yes, my lord. On 21/5/2003, I arrested the accused and forwarded him to court in custody. I had also seized.
Just a minute. Page 51. 5 lines from the top. Yes, read it again once.
On 21/5/2003, I arrested the accused and forwarded him to court in custody. I had also seized one plastic injection series and on one tin dibba containing nagaful liquid and prepared the seizure list. Exhibit 2 and 4 already marked and Exhibit 2/2 and 4/2 are my signature thereon. The accused, while in custody, confessed before me and the witness that he had killed his own daughter by giving poison in the said syringe and led me and the witnesses to the place of concealment, which was behind the house of one Uma Pradhan, and gave recovery of the syringe and the tin dibba containing the said liquid. The syringe was recovered from the body of the house of Uma Pradhan, and the tin dibba was recovered from the house of the accused in presence of the witness as per Caesar list Exhibit 2 and 4. I had
Now,
also.
this has been marked. You come to page number 59 now. That C report जो कौन पठाइथिला. What is exhibit A and what is exhibit B, in which poison was found. Exhibit A 59 is the
It's a series, my lord.
empty injection syringe,
My
okay,
lord. My lord.
said to be contain poisonous substance.
My lord.
B is that diba,
My
tin
lord.
diba, contains so and so liquid substance,
My lord.
said to be poisonous. Then that those two things were examined, and it is found on C that it is containing
Poison.
endosulfan, that is an insecticidal poison,
My
right?
My lord.
So at least the medical report indicates that it's a case of poisoning.
My lord.
Poison was stated to have been administered through injection, right? And that injection syringe and that dibba, which was containing poison, was recovered at your instance on the basis of your statement made under Section 27 of the Evidence Act. If these three things are there, if it is found that the statement of that we have not gone as yet, that lady who is the informant in the case and the mother of that child, if he has seen that you are administering that uh, injection to that child for which there was sudden reaction and the child died. Now we see that evidence, then we'll put question to you. Who is that lady? PW1.
PW.
Come to PW1. She is your second wife, right? And
Yes,
the
ma'am.
mother of that child, right?
Mother of the child and wife of the appellant.
Right.
I knew the accused standing inside the dock, who is my husband. At the time of the occurrence, I was in paternal house at village Ringalpali. Since there was shortage of water in my husband's village, I was left in my maternal house for the purpose of delivery. It was about 1 year back I gave birth to a daughter. Here she is saying that 1 year back she had given birth to a daughter. But after the birth of the daughter, my husband accused had come to see her and went back to his
1
house.
year back means from the date of deposition,
Yes,
1 year back.
right.
When the FIR was lodged, she was just 1 month.
1 month. Right.
So on the date of FIR, she was not examined in court.
Right.
So what is the discrepancy in that way? Yes, continue.
After 2 days, my husband again came to my maternal house. At that time, my newborn daughter was suffering was sleeping in the side the room, and I was cooking in the veranda. When I heard my daughters crying, I rushed there and saw my husband accused giving injection to her belly. After injecting, my husband fled away. When shouted, the neighbor came there and seeing the condition of my daughter, they advised to take her to the hospital. While I was taking my daughter to the hospital, she died at the outskirts of the village, for which I took the dead body to the police station and orally reported before the police, which was reduced to writing, wherein I have put my LTI. After the injection, my daughter turned black before death. Now the cross examination, my lord. Rimal police station is around 6 miles from my paternal village. On the very day of the death, I lodged report at the police station. My mother had accompanied me to police station. The FIR was read over and explained to me. My paternal house consists of only one room. There is no fencing to the house. My daughter was aged 1 month, 1 month, and before her sleep, I had given milk to her. I covered the body of my daughter when she slept. It is not a fact that my daughter died due to suffocation while I was feeding milk to her. She was my first issue. Prior to my marriage, my husband had married earlier and his first wife is alive. She had no issue. Since the first wife was issueless, my husband solemnized his second marriage with me for begetting a child. My daughter was named Rebati, and at the time of her named, my husband was present. It is not a fact that my daughter was ailing from birth. There was marked on the belly of my daughter when injection was given. I had shown that spot to the police. There was little bleeding due to injection, which I had narrated to the police. Prior to that day, no no prior no prior to that no injection was given to my daughter for the welfare of her health. House of Dinu Pradhan is very close to my paternal house. My husband mostly remained with his first wife at village Neharpal, and I used to object that frequently. Now I am not willing to stay with my husband. Hearing my shout, the neighbors immediately came to my house. I did not go to the hospital when my daughter was taken for postmortem. It is not a fact that my daughter died due to suffocation while I was feeding her, and that due to ill uh, ill feeling with my husband, I have falsely implicated him, and that he did not give any injection to my daughter.
So, what is your submission on this evidence of this witness? She is an eyewitness to the occurrence and stated how the injection was administered and what was the reaction of the deceased, uh, that baby, after that injection was given to her by the appellant. And so, if this evidence of this particular witness, who is none else than your wife, and she is not likely to depose falsehood against you. So, what is your submission? Why this evidence of this witness is disbelieved? Is to be disbelieved?
Well, the doctor's report is saying that the child had died due to asphyxia, and now the wife, because she was the second wife, she was not pulling on.
ଯେତେବେଳେ କୌଣସି ଇଞ୍ଜେକ୍ସନ କ୍ୱେଶ୍ଚିନ୍ ପଚାରୁନାହାନ୍ତି, ଇଞ୍ଜେକ୍ସନ ଦିଆହବ, ରିଆକ୍ସନ ହବ, ପଏଜନସ୍ ହେଇଯିବ, ସେତେବେଳେ ମଧ୍ୟ ଜଣେ ଅନଇଜି ଫିଲ୍ କରିବ, ତାର ନିଶ୍ୱାସ ପ୍ରଶ୍ୱାସ ବନ୍ଦ ହେଇଯାଏ। ଦ୍ୟାଟ୍ ଇଜ ଏ ଷ୍ଟେଟ୍ ଅଫ୍ ଆସ୍ଫିକ୍ସିଆ। ଆସ୍ଫିକ୍ସିଆ ସେ ଯୋଉ କହୁଛନ୍ତି କେବଳ ଏଇଟା, ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ ଦି ଓନ୍ଲି ୱେ ଦେଲ ଇଏ ତ give that Modi jurisprudence. Something has been left out. Whatever has been mentioned there, pick and choose କରିକି ତାକୁ ପ୍ରଶ୍ନ ପଚାରିଛନ୍ତି cleverly. But asphyxia, there are so many reasons. If you take poison also, you will feel
Froth will.
and ସେଠି ମଧ୍ୟ, so it is not that and give that legal dictionary. Theology. Asphyxia's plain meaning is a morbid condition of swooning, suffocation, suspended animation resulting in death if not relieved, produced by any serious interference with the normal respiration as obstruction of air passage, inhalation of poisonous gases, or through verified air choking or drowning with a consequent deficiency of oxygen in blood. These are the results. ତେଣୁ ଆପଣ କୌଣସି ପଏଜନସ୍ ସବଷ୍ଟାନ୍ସ ଯଦି ଇନହେଲ୍ କଲେ, ଏୟାର ପଲ୍ୟୁଟେସନ ହେଲା, drowning kale, esu bibhinno karan apart from this pressure in the neck, so that cannot be said. Siye taku pachar dele kon hanging rehi paribo ye basi seti ma koi dele, but rest of the thing he has left out. So which is mentioned that
And even the doctor had not seen any injection mark on the body. No injury.
injection ne kon asibo chotiya
No.
te asibo taro petere se କୋଉ ଜାଗାରେ ଦିଆଯାଇଛି ସେଇଟା ମଧ୍ୟ important. ତେଣୁ ସେ ପୋଷ୍ଟମର୍ଟମ କଲା 1 day after. ଏଇଟା ମତ କରେ close করে এইটা এটা দিয়ে দিন PHY XIA death due to poisonous injection. Enter. Write that poison name. Endosulfan. So poisonous purpurumar. चलिए सर हाँ सेट लग ENDOSULFAN मार So, what do you the respiratory effects have been observed in cases of lethal poisoning from intentional or accidental ingestion of large quantity of endosulfan. Cyanosis, dyspnea, foaming of the mouth, noisy breathing has been observed in several subjects once. It should be noted that these signs and symptoms may also be secondary to swans failure or aspiration of the solvent. So, You see, this is mentioned. This study was made is relating to this endosulfan poison effect. What would be its effect and symptoms, etc. And it is this endosulfan poisoning. 23 cases have been studied, and ultimately the finding is like this. It is mentioned that in our study, nausea, vomiting, abdominal pain had been observed predominantly in up to 2/3 of the cases, and these symptoms continued for 6 hours, and then patient recovered spontaneously. And endosulfan is also toxic to the liver, kidney, and lungs, and can cause so and so in higher doses. Liver function tests in the form of AST and ALT could be abnormal. In our study, there were increased level of AST and ALT in this patient. AST and ALT levels have been lowered with supporting treatment in 2 or 3 patients. However, in one case, it has been transferred to legal transplantation. There was as a severe poisoning may result in death due to status epilepticus that can lead to asphyxia. So these are the various you can find that this poison can also cause asphyxia death. So this endosulfan is an off-patent organochlorine insecticide and acaricide that is being phased out globally. It becomes a highly controversial agrichemical due to acute toxicity, potential for bioaccumulation, and role as an endocrine disruptor. Because of its threats to human health and the environment, a global ban on the manufacture and use of endosulfan was negotiated. And so on so. It is still extensively uh, used in India despite laws against its use. Endosulfan has been used in agriculture to control insect pests, including white flies, so and so, cabbage worms, etc. Due to its unique mode of action, it is useful in resistance management. It can negatively impact population of beneficial insects. Endosulfan is a derivative of hexachlorocyclopentadiene and is chemically similar to aldrin, golden, and so and so. Endosulfan is alleged to be responsible for many fatal pesticide poisoning incidents around the world. Endosulfan can act as endocrine disruptor, causing reproductive and developmental damage in both animals and humans. Endosulfan is acutely neurotoxic to both insects and mammals, including humans. Symptoms of acute poisoning, including hyperactivity, tremors, convulsion, lack of coordination, staggering, difficulty in breathing, nausea and vomiting, diarrhea, and in severe cases, unconsciousness can occur. Doses as low as 35 milligram have been documented to cause death in humans, and in many cases, it has resulted in permanent brain damage. Now, what are the other witnesses have stated in this case?
Other witnesses, my lord.
Come
Kindly
to
have a glance,
PW, come to PW2, let us see.
my lord. She is the mother-in-law of the appellant
Yeah.
and mother of PW1.
Hmm.
Jana Naik is my daughter. She is given in marriage with the accused Nanda Ada, who is now inside the dock. After the wedlock, my daughter gave birth to a daughter in my house since she had come to my house for delivery. It was about 1 year back. Since there was a shortage of water in the village of the accused, he brought my daughter to my house for delivery. On the occurrence day, I was in my bari plucking shaga while my daughter PW1 was cooking and our newly born daughter was sleeping. Hearing the shout of PW1, I came running to my house and found my son in law, that is accused,
Hmm.
running away from the house after injecting his newborn daughter. When we shouted for help, our neighbors rushed to the house and we showed the spot where the injection was given. While we were taking the newborn daughter to the police station, as per advice of the villagers, she died at the outskirts of the village. We took the dead body of my granddaughter to the uh, and police station. PW1 orally reported which report of police used in writing. After injecting my granddaughter, turned black and died. My daughter narrated the entire incident to me. She had not been, but the incident was narrated by the PW1 to her mother. I came to the hospital and was present at the time of postmortem, cross-examination of defense. My daughter was alone at home, and I came hearing her crying. It is not a fact that I have not stated the police to have seen the accused running away after injecting.
সেটা কহিনি পুলিশ পাহাড়ে?
No.
Please come to the PW10. The IO's evidence. Where have you brought out this, proved this contradiction to the investigating officer? Mere confrontation would not do. She has denied that yes, I have stated. Now you have to prove through the IO that yes, in fact, he has not stated. She has not stated. So Come to the last line in page number 53, last 3 lines.
53.
I have examined Guruvari Pradhan PW2. She has not stated before me that she had seen the accused running away with the injection syringe in the hand. Okay. So this means this statement has been made for the first time in court.
My lord.
Okay. Just a minute. That is PW10. Is 53. Okay, but even if that part is excluded, then other things remains that the PW1 was there in his paternal place, in her paternal place.
My lord.
The newly born daughter, the deceased in this case, was sleeping. Then there was a shout, and
There was a cry of the baby, and she ran.
right, and then the baby died on the way to the hospital. So this much at least comes from the evidence of PW2.
Two.
Hmm? And just that the was taking care of the newborn baby. He was now for a future selection. There was good understanding from my Sasu Koji. There was good understanding between the and my daughter after the marriage. After the birth of the daughter, the Akim were attending her and was taking proper care till Namakuram. No, the everything was all right. That is why she was also interested to take both the deceased and the mother. That means PW1 to on decree that there is no water. See that created the problem. That is the prosecution case. She did not agree to go there. That the mother has stated that on account of this particular thing, he came to the since there was shortage of water in the village of the accused, he brought my daughter to my house for delivery. So delivery was there. Because the water problem is there. So uh, okay, you come to the evidence of next witness PW3.
PW3.
Yeah.
He is the seizure.
Hmm?
He is the seizure. The syringe and pinned over.
That syringe was seized.
Pinned over.
I know PW1 as well as the accused standing inside the dock. PW1 had given birth to a daughter through the accused about a year back, and after the death of their daughter, her dead body was brought to the police station where inquest was conducted, and I was present. Inquest report was prepared, and I have signed. Exhibit 1 is the inquest report, and Exhibit 1 by 1 is my signature. Police had arrested the accused, and while in custody, the accused confessed his guilt, admitting to have injected his newborn daughter and to have thrown the syringe and the remnant of the injection inside the body. He also led the police to that place and gave a recovery of the syringe from that body, which police seized in my presence and prepared the Caesar list, wherein I have signed. Exhibit 2 is the Caesar list, and Exhibit 2 by 1 is my signature. Police also recorded the confessional statement of the accused, where I have signed. Exhibit 3 is the said statement, and Exhibit 3 by 1 is my signature. Subsequently, the accused also gave recovery of a tin dibba kept concealed in his house, which police seized. Exhibit 4 is the Caesar list, and Exhibit 4 by 1 is my signature. Cross-examination of the defense. On the very day of the occurrence, police had come to my village for inquiry and arrested the accused from his house at village Neharpara. I was examined by the police. Since the seizure was conducted by police in my presence, I did not tell about those seizures to the police. It is not a fact that the seizure lists were prepared at Deoghar and not at the spot. I do not know the contents of the writing on the label of the tin dibba which was seized from the house of the accused. The contents of the seizure list were read over and explained to me. I was present at the time of the post-mortem examination, but I have not noticed the mark of injection on the body. I do not find the tin dibba in court today. One Lochan Sahu was present with me, although we had also gone to the village Neharpal. The first wife of the accused was there in his house. I was present when police interrogated the accused. It is not a fact the police gave threatening to the accused. My daughter-in-law has filed a case against me alleging dowry torture. It is not a fact that PW1 and her mother are witness in my favor in that case. It is not a fact that there was no such confession leading to discovery and seizure, and that the newborn child of PW1 died of suffocation while breastfeeding her, and that the accused is falsely implicated in the case.
So, doctors, if you see that what was the reaction of that poison that the doctor has stated PW4, body was looking bluish,
Bluish.
number one, tongue was protruded and bluish, then face was bluish, then viscera were intact, so and so. Mode of death was asphyxia, and we have already seen that poison, if you take that, this can several reaction would be there prior to the death, and one of the reason may be asphyxia also. It is not uniform that everything would appear all those reactions in one single case. It may differ depending on the resistance of that, depending on the age of that person. So here the small child suddenly got the color changed, and she felt perhaps breathing problem, and that led to the choking of that breathing, and that is the asphyxia. So uh, uh, so whatever we find that apart from the evidence of this PW1, who is an eyewitness to the occurrence, the next is the leading to discovery of that injection and that dibba, which was seized, and it was sent for C examination as and the C report also indicates that both dibba and that injection containing poisonous substance. And the doctor, of course, not marked any external injury. External injury means in the sense it is just an injection given at a particular.
My lord, kindly have a glance to the opinion of at page 40, last line of the opinion, my lord. Just 1, 2, 3, 4. Fourth line of the opinion, paragraph 2. Here's the doctor say injury is a must when there is a prick of injection. But doctor is saying that no injury, no mark has been seen by the doctor.
इंजेक्शन देले केतोड़ा को इंजेक्शन अछि जो स्पॉट रे देले केतोड़ा फुली जाए माने स्वेलिंग हुए पिला मनकर immediately but there are different spots माने बॉडी रो विभिन्न पार्ट रे विभिन्न इफेक्ट करता है जोठी particularly muscular part थिवो that may be cause different type of तेणु एठी
But a point mark must be there.
abdomen portion ତେଣୁ abdomen portion ରେ ସିଏ ସ୍ପେସିଫିକ କହୁନି ମାନେ abdomen portion ରେ କୌଣସି just ଗୋଟେ କହୁଛି no external injury ଏମିତି କରି କହୁଛି
No, he's
But-
saying that injury is a must
ହୁଁ
when there is a prick by injection.
ହୁଁ
So there must be a mark. But doctor is saying that he had not seen any mark during the postmortem. He's
Which
using
line
word
you
must, my lord.
which line you are showing
My lord, opinion 1, 2, 3, 4th line. Second paragraph from 4th line, madam.
Hmm.
Page 40.
Hmm.
Injury is a must when there is a prick by injection.
Hmm.
No serious.
We override the particularly if we take into account the surrounding circumstances, the recovery, the that chemical report, examination report. এটিকে আসলো এটা মারলো দে delete from your margin. Injection এটা ইনটাও 2 করো তারপরে ছাড় দিও মানে ইনজুরি করো তার সাইড ইনজুরি স্ট্রাইক করো এন্টার মার You see, the entire body has become blue
My lord.
due to the effect of that. So there is possibility of missing that also. It's not a normal body. Our body a color change normally. So, but because of the effect of poison, the body turns blue. Bluish. ସେଥିପାଇଁ ସେ ଇଏ ମଧ୍ୟ କହୁଛି ଯେ ତାର it's a poison and asphyxia bluish ହେଇଯାଇଛି ଏଗୁଡାକ lesser effect of off level. Let me see. Poisonous. Bit of poison. Injection on child. Enter. Can cause nausea, vomiting, seizures, poisonous means also can cause serious health concerns, including responsive slow, depressed breathing, unconsciousness, and seizures. Yes. The baby कर दिया injured baby and yeah, 1992. Can phone for change one traditional. I don't check with that. Point may not, little, may not external injury, enter. କହୁଛନ୍ତି ଯେ wound ଏତେ small, inconsiderable and not distinct, and but its symptoms will be there, and it would not be that distinct, କାରଣ ତାର ଯୋଉ reaction ହେଇଯାଏ bodyରେ ଏଠି ଯେମିତି blue color ହେଇଯାଇଥିଲା। ଆମର ଏଇ ଯୋଉ ଇଞ୍ଜେକ୍ସନ ଗୁଡାକ ସବୁ ପିଲାମାନେ ନିଅନ୍ତି ତାଙ୍କର ବେଳେ ବେଳେ ଫୁଲିଯାଏ, ସେଥିପାଇଁ ସେ କେତେ ଜଣଙ୍କର ରିଆକ୍ସନ ଯୋଉଗୁଡାକ କେତେ ଗୁଡାକ ଇଞ୍ଜେକ୍ସନ ଗୁଡାକ ଯୋଉଗୁଡାକ ଆଗେ ଦିଆ ହଉଥିଲା ସେଗୁଡାକ ଫୁଲେଇ ଦବ ତାପରେ ଧୀରେ ଧୀରେ ଯୋଉଗୁଡାକ ବନ୍ଦ ହେଇଗଲା, ଯୋଉଟା ବସନ୍ତ ଟୀକା ଏସବୁ ନିଆ ହଉଥିଲା। Which are the best effective of malaria for the pain of the clinic. That's what I think. But the dysphometric collapse, it will have definite reaction in the body of the baby. The body reaction is there, very much. The reaction is the change. No, once the body turns, entire body has become bluish. The body has become bluish. Tongue is protruded, bluish, fingertips, face is bluish, and पूरा देह नीला पड़ गया। And that is why the reaction of that poison. Who are the other witnesses? 7 has not supported the prosecution.
7 and 9 did not.
And what about the 6 case?
6 is the father-in-law of that.
Father-in-law. Here,
He was also post occurrence.
my lord.
Okay, then 8.
8 right.
He is a co-villager man.
Private bus conductor.
But the syringe and also dibba, those
Ma'am.
were recovered from different places, not one place.
Syringe,
And series, the place where the series
the
was
dibba
recovered, that
is seized from the house of the
No. Those were recovered from, as per the statement of the IO, at least 51,
my lord.
towards middle. The syringe was recovered from the body of the house
Uma
of
Pradhan.
Uma Pradhan.
My
Who is
lord.
Uma Pradhan?
She has not been examined.
And the tin dabba was recovered from the house of the accused.
my
The
lord.
syringe were recovered from somewhere else,
Not the same
not
place.
from one place.
No.
So
He might have
he has thrown, might have thrown. So
Uma Pradhan was not examined.
No, my lord.
at the instance of your instance, that dibba and that syringe which were recovered and sent, that was found to contain poison, and one poison was there, that it's not a that different.
No.
If the poison would have been different in dibba, it would have been different than the syringe. Matter is different, but the same poison which was found in that dibba was also available in that syringe. Now PW8's evidence also said that he came to there, and she was intimated, he was that about the appellant administering that poison.
PW7 is the first wife of the accused.
My lord.
Appellant. PW7 is the first wife of the appellant.
No.
Yes, page 52, paragraph 2.
Page 52.
I have examined Ranu Pradhan, PW7. He has stated before me that hearing the hula of PW1,
My lord.
she went to her house and heard from PW1 that her husband Her husband means PW1's
One
husband.
husband.
She is also a co-villager.
Co-villager.
Married.
Both Pijab Behra, PW9 as well as PW7, they have not supported
No.
They have not.
though the IU says that those were witness to the
They have stated in
their
160.
state. And PW9 stated before the police that the appellant was holding an injection syringe in his hand. I was no witness from the village neighbors who were called to the witness to the contents of the statement.
And this further examination of the doctor who conducted post-mortem examinations in paragraph 3 is very relevant that he received a query from the police to opine whether injecting pesticide by a syringe will lead to death or not, to which he replied that death in such case is possible. And the cross-examiner has put a question that presence of pesticide in blood can only be ascertained on chemical examination of the blood and viscera, and that the viscera has been preserved, and in the viscera also that this not only A and B but also in the viscera that means
found
in
same
the
pesticide.
parts of that lungs etc. That they are also poison, that same poison.
Same poison.
It's a very clinching evidence against you. No, because of this reaction, immediate reaction, that was not there. But otherwise, these things are, and viscera eta hauchi viscera hauchi ଗୋଟେ portion of the pathway internally, so that preserve abdomen, lungs, ସେଠି ମଧ୍ୟ ଦେଖାଗଲା ଯେ ଏଇ poison ଯୋଉ poison P60 endosulfan is an insecticidal poison which was detected in A. এটা ହେଲା syringe, ହେଲା B ଟା ହଉଛି ସେ ଡିବା and in viscera. ଟେଷ୍ଟ ପାଇଁ ତାର ସବୁ ବଡିର ଇଣ୍ଟରନାଲ ଜିନିଷ ଗୁଡାକ। এটা হচ্ছে page number 58 ରେ ଅଛି। Endosulfan is an insecticidal poison was detected in the KC report, original C report. ମାନେ injection and ଗୋଟେ ନିଜ ଘରେ ରଖିଥିଲା ସେ ଯୋଉ injection syringe ଟା ଗୋଟେ ପଡିଥିଲା ସେଠୁ recovery କରିଦେଲା ଏଇଟାକୁ ଦେଲା ଆଉ ସେଇ particular ମାନେ nature of the poison that ତିନିଟା ଜାଗାରେ B and body ସେଟା body recovery collection and then only poison medicine We can say that what was recovered from the actually that the instance of the disease is not the cause of death of the disease. Into but this doctor, this PM doctor, that is PW
4.
4. He has also stated that it can be known after the chemical examination of the viscera.
Yes, madam.
तो सारा original report टा टिके देखले बाहर कले ए PM report टा होची exhibit 6 टा टिके बाहर से थोड़ा बंद करो
ऊपर के नहीं।
पोस्टमार्टम रिपोर्ट सेकंड पेज को जाओ मैंने एटा क्वेरी रिपोर्ट टा तार पछपटा पड़ल एटा एटा ऐसे ये ओरिजिनल एटा PM report टा सेटा मार्क हिची exhibit 6 ना
Exhibit 6.
exhibit 5 ना 5
Five.
there
And this is
mode of death was due to asphyxia. The cause of death was reserved only given after the chemical examination. It reserved this year. Viscera found would have preserved in saturated solution, stomach, and a portion of the intestine. Piece of the long liver, spleen, kidney, colored for saturated solution. That was the color C intelligence. Inter jaha was full of fully body was injuries. The river motifs song was protruded and given recently. So, basis except that particular statement of the doctor, there is nothing in your favor. That you injury ta kuchi dekhinali, baki eyewitness leading to discovery of injection and that syringe. CE report, PM report of finding that viscera preserved ହେଇଥିଲା ଏବଂ same poison was detected
Madam.
in these three. ସେଇଗୁଡାକ
And what my humble submission is what made him to do so? Because there was no compatibility between the husband and wife. The husband wants to take her back after the delivery. He has even asked her, to which she denied. And the wife is also in a statement saying that she's not willing to go right now, or she doesn't want to stay with him. Rather, the PW2, the mother-in-law, she is saying the
you
contradiction.
see, she came to her paternal place at the time of delivery. Okay, there
Delivery.
was some kind of problem of water. That is the reason she came to her paternal place.
My lord.
Stayed there, delivered the child, right? The
My
deceased delivered the child. Husband came to take her,
my
right?
lord.
She didn't agree.
She did not.
The reason has been assigned in the FIR that there is water problem
Scarcity
there
of
in my
water.
husband's house,
Yes, sir.
and myself and my baby girl, we just 1 month they will face problem. That is the reason why she didn't agree to go with her husband.
My lord.
So what would be its reaction? It depends upon person to person.
My lord.
You are saying that this is for this small reason why she would take it as exception.
No, my lord.
ସ୍ତ୍ରୀ ମନା କରିଦେଲା ନାଇଁ ମୁଁ ଛୁଆକୁ ନେଇ ଅଇକା ଯାଇପାରିବିନି, ମୋ ଛୁଆର ଅସୁବିଧା ହବ, ତାର ଇମ୍ପାକ୍ଟ ଗୋଟେ ସ୍ୱାମୀ ଉପରେ କଣ ହବ? It depends upon person to person. Some may take it lightly. ହଁ ଅବିକା ନ ଆଇଲା ଆଉ କିଛି ଦିନ ପରେ ତ ଯିବ ଆଉ କଣ, ସେ ରହୁ ବାପ ଘର ତ ରହିଛି ଆଉ ରହି। ଆଉ ଗୋଟେ ଲୋକ ମୁଁ ଯାଇଥିଲି, he may react differently.
My
So
lord, she had stated at page 33, she had herself said, my husband mostly remained with his first wife at village near Par, and I used to object that frequently. Now I am not willing to stay with my husband. Hearing my shout, the neighbors immediately came to my house.
you see, the child was with the mother,
My lord.
right? Child has died and it's a case of poisoning.
My lord.
Right, poisonous substance ଛୁଆକୁ administered ହବା ଯୋଗୁ death ହେଲା. So she has stated that I saw that this came, injected something, ran away, and then there was reaction. So who has caused it? Either the mother not accused.
Accused.
So the accused's presence at the scene of occurrence, then administering injection was seen by none else than the wife of the accused, and your wife is giving evidence against you. Why she would depose falsehood? If she know that what would be the consequence, that if I depose my husband is in jail, she might. So one child is gone, all right. But if I depose against, so there was every chance of not supporting the prosecution case, turning hostile.
My lord, the other contradict statement of PW2, kindly have a glance.
PW2 is a post-occurrence witness.
No, after hearing the voice of the PW1,
Yeah.
she came running away from the bari. She was
Right.
plucking the saga.
Right.
In that she's saying,
she has stated that I saw the accused running out.
my lord.
But that statement was not there before the police, so let us exclude that. Let us exclude that she has not seen the accused running away. How do you meet the evidence of the PW1, who is the mother of the deceased and wife of the appellant, and seen the appellant came, administered one injection, and then the reaction is this, and which is getting corroboration from the C report that the injection which was seized at your instant, that syringe, that dibba and viscera which was preserved by the doctor who conducted post-mortem examination, all these contain one poison, that endosulfan poison. So if we are discussing, if the poison would have been different, matter is something different. But the same poison which was available with you in your house and was given in that syringe which was recovered at your instance was the very poison that was administered to that deceased, which resulted in the death. Because the PM doctor has subsequently stated that a query has been made whether by administering poison pesticide the death can be caused. The doctor has answered yes. So other witness, what they have stated, some have not supported matters is different. But when your wife is telling, deposing against you, and this is the clinching circumstance, how can you get over it? It's a eyewitness account and supported by the medical evidence and C report. Only one line of the doctor's evidence is that
He had not seen
he did
any
not
injury.
noticed any injury on the abdomen on which portion the injection is
Injection was
stated to have
injected.
been administered.
My lord.
But again, the thing is that she has stated that the entire body has become
Turned
bluish. So therefore, maybe that would not be noticeable at that point of time. So
And my lord has already said that the opinion evidence is not substantive piece of.
that
That
is another aspect. When ocular evidence is clinching and trustworthy, suppose the medical evidence here does not negate it. Medical evidence only indicates that no injury was there in the body. Okay, but on the one side, if the ocular evidence is trustworthy, several decisions are there. So court may not look into that medical evidence, or here the evidence of that lady that poison was administered by way of that injection is getting corroboration from the C report. And the symptoms of that child, 1 month child, what has happened, entire bluish there. When the occurrence took place, that was on 20.
25
Yes,
2000.
on the very next day, that
He was
was
arrested.
recovered at your instance from your house.
Yes,
And
madam. The body of Umab, from the body of Umab.
the cross-examiner has put question that as if during breastfeeding, he says that the suffocation, but how the poison would come? Maybe suffocation is different part, but from viscera, how poison would come? Which person?
Hmm?
Come to the fore, it may not come to the fore. ଜଣେ ଜାଣିପାରିବନି ୱିଟନେସ୍ କଣ ଜାଣିବ ୱିଟନେସ୍ ଦେଖିଲା ଏଇଆ କରୁଛି କଣ ପାଇଁ ସେ କଲା he may not so that is why direct evidence ରେ motive ପ୍ରମାଣ ନହେଲେ ମଧ୍ୟ it can be convicted but ସେଟା ଯଦି circumstantial evidence ଅଛି motive ଯଦି ନାହିଁ then it puts the court on guard to verify the other evidence as to whether because that is very relevant thinking circumstantial evidence it's a case of direct evidence ଦେଖିଲା ତାକୁ picking କରୁଛି so that is the creating the problem. Otherwise if so ଛୁଆଟାକୁ କାହିଁ ମାରିବ ଯଦି ସ୍ତ୍ରୀ ନ ଆସିଲା ହୁଏ ତ ମାନେ ଜେନେରାଲି ଯେ ହେଇପାରିଥାନ୍ତା to failing to have to fulfill his sexual desire. He committed such a crime because his wife coming to his house publicly. সেটা তার কেস নয় সেটা তার কেস
She was taken. And the stage is passed by to the child was supposed. Objective. ସେମିତି ଦେଖିଲେ ନାନାଦି ହାଇପୋଥେସିସ୍ ଗାଡ଼ି ମନେକର ସିଏ ରାଜି ହେଉଥିଲା ମୋ ଛୁଆଟା ଡିଫିକଲ୍ଟି ଫେସ୍ କରିବ ତା ସାଙ୍ଗରେ ଅଧିକା ମୁଁ ଯଦି ଆକମ୍ପାନୀ କରେ ତା ଘରେ ପାଣି ନାହିଁ ଇଏ ତ ନେଇ ସେଇ ତ ଏକ୍ସେପସନ୍ ଏଇ ଛୁଆ ସହ ମାନେ ଆସୁଛି ମାନେ ହର୍ଡଲ କ୍ରିଏଟ୍ କରୁଛି ଛୁଆଟିକୁ ମାରିଦେଲେ କି maybe so what would happen strike at the mind of a person so that is very difficult to that is why spontaneous କେସରେ କ'ଣ ମାନେ ହଁ ସିଙ୍ଗଲ ବୋଉଦେଲା but poison କେସରେ either you are accused him there is no other infinite at all and these are the two grounds like IO statement also the doctor statement ଆଇଓଟା ହଉଛି ଯୋଉ ଇନକ୍ୱେଷ୍ଟ ବେଳେ କିଛି ଇଞ୍ଜୁରି ଦେଖିଲା ପୋଲିସକୁ ଦେଖେଇଲି ନା କଥା ପଡିଛି ନା ଆଉ ଡକ୍ଟର ବି କହିଛି question is that possibility ରହୁଛି ସେ injury admittedly and poison was administered but what was the mood of administering poison and who did that did that believe the evidence of PW1 because that has not that has not been second she was the only yes that has not been second it's very clear last 3 lines is very relevant. At that time, I knew that was sleeping and when I heard my daughter crying, I rushed there and saw my husband sitting in a single room. I didn't know boundary was. But I was asking what and I heard my daughter crying there. I saw my husband giving injection to her belly. After injecting the my husband fled out. Husband giving injection to her belly. Suggestion देखो ना दिया it is not a fact that my daughter died due to suffocation while I was feeding. It cannot be. If that would have been the mode of death, then there is no question of poison being detected. There was a mark on the belly of my daughter when injection was given. Which is I also like the doctor. They say otherwise. No, I thought so. That spot to the police security, I had saw
Right,
that
right.
spot.
This occurrence took place. Like, what is the time of occurrence?
मैं पुलिस की देखी मैंने चित्र में
हाँ, मैं
आयु कुछ नथिला
ସେଇଟା ହଉଛି
पुलिस की देखेगी
20 ଘଟଣା ହଉଛି 20 ତାରିଖ ଦିନ ଦିନ 10ଟାରେ ଇନଫର୍ମେସନ ଦେଲା ଦିନ 4ଟାରେ ମାନେ ପ୍ରାୟ 6 ଘଣ୍ଟା ପରେ ତାପରେ ଇନକ୍ୱେଷ୍ଟ ହେଇଛି।
पुलिस की देखी
ହଁ ପୋଲିସ ସେ ଲାଇନଟା କୋଉଟା କହୁଛି ଏପିଡବ୍ଲ୍ୟୁ
then I had given that spot. That was last what one day. 32. There was mass of failure of my daughter from injection where injection. I had shown that spot to the police. There was a little bleeding due to injection which I had narrated to the police. People should be just bleeding now. But again, I have pushing up here, doctor picking up here. After that, no injection was put with that. Doctor said, injection दिया है नहीं. It's very close to me. Confession before the police. See, I have a Saketa Purivar, perhaps could be that confession statement.
No, that confession is inadmissible being hit by 50-25, but leading to discovery is also
My husband was to remain with his first wife that was sunshine. The objective frequently now I am not willing to stay with him. There might be something in the body will receive. I will be that. So which is it as well and criticize from me. I think you because of that we got. He can see. He has left that lady. That was just a little bit of the young sort of not taking it. Something that can make you.
that is true. How can breastfeeding child like just breastfeeding? That's a different, but breastfeeding for those who I
Differently, an officer well, that's what we think of the federal system with the recently. So, man, actually, maybe there is like a must say that use. Section I think not a fine for
says just breastfeeding very suai message. They say evidence paper.
and then one of the American books, but that was like the police with the KG, like the police one.
Not it's not. Yes, the suggestion which you have given, it's a very dangerous suggestion that the particular mode of death, the defense suggestion that
Because
he
of-
died due to this
Because of suffocation.
waste feeding. If that would have been the case, how can
Poison
you
would
do a
not-
poison?
Poison would not have. I appreciate.
ସେଠି ସଜେସନ ଦେଲେ ସେଇଆ ଏବଂ ଲାଷ୍ଟ କୁ ମଧ୍ୟ ଆପଣଙ୍କର କେସ୍ ହଉଛି ଯେ ମଧ୍ୟ ଯୋଉ ଲାଷ୍ଟ 4 ଲାଇନ୍ସ in page 33 that it is not a fact that my daughter died due to suffocation while I was feeding her and that due to ill feeling with my husband I have falsely implicated him and that he did not give injection to so and so. That ସେଇ poison ରୁ ଆମେ ବାହାର କରି ଯୋଉ ଦେଖୁଥିଲୁ it's a very dangerous one. ଆପଣ ମାନେ even healthy ଲୋକକୁ ମଧ୍ୟ ସେ ଯୋଉ ଖାଇ ଦିଅନ୍ତିନି ଯୋଉ କୀଟନାଶକ ଗୁଡାକ
ହଁ।
ତାର immediate reaction ବହୁତ dangerous କାରଣ ଏଗୁଡା ସବୁ ଏଇ ଯୋଉ ପୋକ ଗୁଡାକ ହୁଅନ୍ତି
Flying insect.
ହଁ ତାଙ୍କୁ ଇଏ କରିବା ପାଇଁ ସେଗୁଡା ଥରେ ପକେଇଦେଲେ ଆଉ ସେଗୁଡା ଆସନ୍ତିନି ଲାଗେନି କିନ୍ତୁ ତାର ବହୁତ harmful effect ଅଛି
For the human organ.
human
Right.
ଆଉ ତାକୁ ଗୋଟେ ଛୋଟ ଛୁଆଟା ଯିଏ ମାସେ ହେଇଛି ତାକୁ ତମେ ପଏଜନ ମାନେ ଇଣ୍ଟ୍ରାଭେନସ୍ ମ୍ୟାଟ୍ରୋ ଏଇଟା ଯଦି ହୁଏତ ଓରାଲି ଦିଆ ହେଇଥାନ୍ତା ସେ ହୁଏତ ବାନ୍ତି କରି ପକେଇଥାନ୍ତା ବଟ୍ ଯେତେବେଳେ ଇଞ୍ଜେକ୍ସନ
Inject
କରି
କରେ।
ଦିଆହେଇଛି ଇମିଡିଏଟଲି ରିଆକ୍ସନ ହେଇଛି ଯୋଉଥିପାଇଁ ବ୍ଲୁଇଶ କଲର ଆସିଛି
It has spread throughout her body.
Madam?
The said poison has spread throughout
Throughout
her
the
body,
body. Throughout.
different organs.
Right.
Where from this sample were taken and it was medically examined.
I know that the total case is against me and all materials are against me, but I can only pray that he is in custody
No,
since
we are also thinking that
19
can there
years.
be once we found
No.
that
Since
appellant
2014, he has been released on bail.
Interim
He's
bail.
not in custody.
That
he-
part I don't have the record.
2014
I don't have the record.
he has been released on bail.
On 17/6/2014. Prior to that, he was on interim bail for 6 weeks.
That part I don't have the knowledge because I don't have the materials available.
Because in a case of this nature, once you find the appellant guilty means there is no other type of punishment you can give except
Except
that life
life
imprisonment.
imprisonment.
302 life imprisonment. ତେଣୁ ଏଟା ନୁହେଁ ଯେ ଗୋଟେ ପାହାର ଦେଲା କାହାକୁ ଇଏ ହେଲା ସେ ଅଲଗା କଥା ସେ but
We had no intention to kill.
ହଁ ସେମିତି okay, take down JCRLA number
citing
one
a judgment, Your Lordship.
हाँ
The export opinion over.
हाँ
I do not have the copy.
Hmm.
It is 1992 3 SCC 204, Your Lordship.
हाँ देई दियो citation ଟା हाँ
It's
ଆଉ କୋन citation
the medical opinion
नहीं
being
नहीं आगे citation ଟା कोन
1992 3 SCC
1992
3 SCC
yes
204 ପାର୍ଟିଟା ହେଲା ମଦନ ଗୋପାଲ versus ନାଭାଲ ଦୁବେ
ମଦନ ଗୋପାଲ versus
ନାଭାଲ ଦୁବେ
NAVAL
ମାଇଲର
ତାପରେ ନାଭାଲ
ଦୁବେ DUBEY
BEY
DUBEY
कौन what is the ratio let
the
down
medical opinion being an opinion in an advisory nature and not binding upon the court. That court has to form its opinion considering the material data and the opinion on the technical aspect rendered by the medical expert.
no
Yeah.
even there are decisions to the extent that where the oral evidence is consistent clear trustworthy
And
merely because the medical evidence
yes,
it
because
is,
it is opinion,
it's opinion
not a
evidence
substantive
so
piece
that cannot supersede the oral evidence which is take down JCRLA number 124 of 2005 the appellant Nanda Adha faced trial in the court of London Additional Session Judge Deogar in Sessions Trial number 2 of 2004, ST number 436 of 2003 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 20th May 2003 at about 10 a.m. at village Rengalpalli, he committed murder of his daughter Revati bracketry hereafter the deceased. The London Trial Court by judgment and order dated 18th November 2004 found the appellant guilty under the offense charged and sentenced him to undergo imprisonment for life. As per the first information report lodged by Janho Naik, bracket PW1, the mother of the deceased, before the officer in charge of Riyamal police station on 25/2003. In short is that she married the appellant and she was the second wife of the appellant. And out of their wedlock, a female child was born who is the deceased in this case. And at the time of occurrence, she was just 1 month old. It is further stated in the FIR that since there was scarcity of water in the house of the appellant, She came to stay at her paternal place at Rengalpally at the time of her delivery. And after giving birth to her to the deceased, she was also staying there at her father's place. And the appellant used to visit her sometimes, and 3 to 4 days prior to the occurrence, the appellant came to her paternal place and compelled her to accompany him to his house. PW1 was unwilling to accompany the appellant on account of scarcity of water there in the house of the appellant. And she assured to go there in the rainy season. At this, the appellant got angry and tried to take away the deceased. But PW1 didn't allow the appellant to take the deceased with him. It is further stated in the FIR that on 25/2003 at about 10 a.m., while she was cooking rice on the veranda of the house, and the deceased was sleeping inside the house, the appellant came and entered into the room where the deceased was sleeping. Suddenly, PW1 heard cries of the baby of the deceased person, and ran inside and found that the appellant was administering injection on the abdomen of the deceased. And seeing PW1, she took out that injection and fled away. Immediately, the deceased having had some reaction on the body, and her body became black and became stiff. Noticing the health condition of the deceased, PW1 shouted that the appellant had administered poisonous injection to the deceased. And She also informed the co-villagers about the same. The villagers advised her to take the deceased to the hospital. And while taking the deceased to the hospital, on the way, on the outskirts of the village Rengalpali, due to the side effect of poisonous injection, the deceased PW1 came to Riamal police station and orally reported the matter before PW10 Shanatan Mahakud, the OIC of Riamal police station, who reduced the same into writing, and it was read over and explained to PW1, and when she admitted it to be correct, her thumb impression was taken on the report, which was treated as first information report. And Riamal PS case number 50 dated 25/2003 was registered under section 302 of the Indian Penal Code against the appellant. PW10 took up investigation of the case, examined the informant, other witnesses, held inquest over the dead body, prepared the inquest report Exhibit 1, sent the dead body to the district headquarters hospital, Devgarh, for postmortem examination, arrested the appellant on 21/5/2003, and on the basis of the statement of the appellant, and at his instance, one syringe was recovered from the backyard of one Uma Pradhan, and one tin diba containing some liquid substance was recovered from the house of the appellant in presence of the witnesses as per seizure list Exhibit 2 and Exhibit 4. PW10 received the PM examination report, and he sent the plastic injection syringe, tin diba, along with the viscera collected by preserved by the doctor who conducted postmortem examination to the SFSL Rasulgarh for chemical examination through SDGM Devgarh. He made a query to the medical officer who conducted the PM examination regarding death of the deceased, whether the death of the deceased could be caused by pesticide injection, poisonous injection, and the doctor opined in affirmative, and as per his opinion, by Exhibit 6. He received the C report from the SFSL Rasulgarh by Exhibit 11, and on completion of investigation submitted charge sheet under section 302 of the Indian Penal Code against the appellant. Next para. After submission of the charge sheet, the case was committed to the Court of Session, where after complying the due procedure, where the Learned Trial Court framed the charge against the appellant under section 302 IPC, and since the appellant pleaded not guilty and claimed to be tried, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 10 witnesses. Give the detail. 11 documents were exhibited from the side of the prosecution. The defense plea is one of denial. However, it was suggested to PW1 that the deceased died due to suffocation while PW1 was feeding the deceased. And since she was having ill feeling with the appellant, she has falsely implicated the appellant. The Learned Trial Court, after assessing the oral as well as documentary evidence, came to hold that the medical opinion given by the doctor goes to show that the death of the baby could be possible by injecting pesticide through a syringe. The Learned Trial Court accepted the version of the eyewitness PW1 PW2, PW6, and PW8 as truthful witnesses, and came to hold that from the oral and medical evidence adduced by the prosecution, it is crystal clear that the appellant is solely responsible for intentionally causing murder of the deceased by injecting insecticide poison with an injection syringe. The evidence of PWs 1, 2, 6, and 8, coupled with the medical report and the chemical examination report, clearly goes to show that there is strong circumstance against the appellant, which pointed out accusing finger on him, who is squarely responsible for the homicidal death of the deceased baby. And accordingly found the appellant guilty under section 302 of the Indian Penal Code. This is Suman Modi, Land Council, appearing for the appellant, contended that even though the evidence of the eyewitness PW1 indicates that the appellant gave injection on the belly of the deceased, but and further stated that there was mark on the belly of the deceased when the injection was given, and she had shown that spot to the police, and there was little bleeding due to injection. But the IO bracket PW10 has stated that at the time of inquest, she could not notice any mark of injection on the belly of the deceased. The learned counsel further argued that even the doctor who conducted post-mortem examination has stated that injury is a must when there is peak by injection, and therefore the evidence of PW1 that he saw the appellant giving injection on the belly of the deceased, which resulted in her death, is not acceptable. It is further argued that from the evidence of PW1, it appears that good relationship PW1. One, two कर दें. PW2, who is the mother of PW1, has stated that at the time of the birth of the daughter, the appellant was attending her and taking proper care till Namakaran. And there was good understanding between the appellant and PW1 after marriage. And therefore, there was no motive on the part of the appellant to commit murder of the deceased merely because PW1 didn't agree to accompany him to his house or didn't allow the baby deceased to be carried by the appellant. The Land Council submits that since the case mainly rests upon the solitary evidence of PW1 and her evidence is not clinching and trustworthy, and it is not corroborated by the medical evidence, it would be risky to accept such evidence to convict the appellant. And therefore, it is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Rajesh Tripathi, London Additional Standing Counsel, on the other hand, supported the impugned judgment and argued that PW1, being the wife of the appellant, was no axe to grind against him, and she was not supposed to implicate her husband falsely in a case of murder. And her evidence as an eyewitness has not been shaken at all in the cross-examination. The London Council further argued that the evidence of the PW1 not only gets corroboration from the medical evidence adduced by PW4, but also the recovery of the injection syringe and DIBA. So also the viscera of the deceased were sent for chemical analysis, and the C report marked as Exhibit 11 clearly indicates that endosulfan, an insecticidal poison, were detected in the exhibits marked as A bracket ray injection syringe, B tin diba containing liquid, and viscera. The Land Council submits that in view of the available material on record and the manner in which, being the father of the child, the appellant had administered poisonous injection to the baby who was just 1 month old at the time of occurrence, the London Trial Court has rightly found the appellant guilty under Section 302 of the Indian Penal Code, and therefore the appeal should be dismissed. Adverting to the contention raised by the London Council for the petitioner, let us first examine the evidence of the star witness on behalf of the prosecution, who is none else than the informant bracket PW1, the wife of the appellant and the mother of the deceased. She has stated that at the time of occurrence, she was in her paternal house at village Rengalpalli, as there was shortage of water in the village of the appellant. And she came to her paternal place for the purpose of delivery, where she gave birth to the deceased. And she further stated that 2 days the appellant, after the birth of the deceased, the appellant had come to see her and went back to his house, and after 2 days again he came, and at that time the newborn daughter bracketer deceased was sleeping inside the room and she was cooking in the veranda. She heard the deceased crying and rushed there and found the appellant giving injection on the belly of the deceased. And after injecting, the appellant fled away. That should happen. Uh, she further stated that she shouted, for which the neighbors came there, and seeing the condition of the deceased, they advised to take her to the hospital. And while taking the deceased to the hospital, she died on the outskirts of the village, for which she took the dead body to the to the police station and orally reported the matter. In the cross-examination, she has stated that her daughter, bracketer deceased, was aged 1 month, and that before her sleep, she had given her milk. Suggestion was given to PW1 that while she was feeding her baby, there was suffocation, for which the deceased died. But she has denied the same. She further stated that out of the first marriage of the appellant, since there was no issue, the appellant married her for the second time for begetting a child. In the cross-examination, it has been further elicited that there was mark on the belly of the daughter when injection was given, and she had shown that spot to the police, and there was little bleeding due to the injury. And prior to that date, uh, due to administering injection, and prior to that date, no injection was given to the deceased. She further stated that the appellant used to remain with his first wife at village Nehrapal, and she used to object it frequently. The evidence of PW1 is getting corroboration from the evidence of PW2, who is her mother, and stated that due to shortage of water in the village of the appellant, the PW1 was brought for delivery. She further stated that while he was in the backyard, she heard shout of PW1 and came running and found the appellant was running away from the house, and she shouted for help, for which the neighbors rushed to her house. In the cross-examination, it has been confronted to her and proved to the IO that she has not stated before the police to have seen the appellant running away after injecting. Since such a statement has been made for the first time in court, we are not inclined to place reliance on that part of the evidence. However, the statement of PW2 that she heard the shout of PW1 and came running and thereafter the newborn daughter bracket deceased was shifted for medical treatment, but on the outskirts she died, corroborates the version of PW1. The doctor who conducted the postmortem examination has noticed the following external injury. And on dissection, she found as follows. And she opined that the mode of death was due to asphyxia, and she reserved the final opinion awaiting the chemical examination report of the viscera, which was preserved by him. He proved the report exhibit, a postmortem report exhibit 6. In the cross-examination, she has stated that the possibility of the death of the child while breastfeeding cannot be ruled out, but it is remote. He further stated that injury is a must when there is a peak by injection, and no syringe was produced before him for her examination and opinion. And he did not notice any sign of injection on the body of the deceased at the time of postmortem examination. However, in the further chief examination on recall by the prosecution, he stated that he received a query from the police to opine whether by injecting pesticide by a syringe, it would lead to death or not, to which he replied that death in such case is possible, and he proved his report to that effect. At the instance of the appellant, basing on his statement recorded under Section 27 of the Evidence Act, one syringe was recovered from the backyard of one Uma Pradhan, and a tin dibba containing some liquid was seized from the house of the appellant. And in that respect, the evidence of IO bracket ray PW10, so also the evidence of PW3 are very clinching, and nothing has been elicited in the cross-examination to dislodge such statement. The plastic syringe, no, the injection syringe marked as A, the tin dibba marked as B, which were seized at the instance of the appellant, so also the viscera collected by the doctor during postmortem examination were sent for chemical examination And the chemical examination report bracket exhibit 11 indicates that endosulfan, an insecticidal poison, were detected in the exhibit marked as A, B and in the viscera. The submission of the London Council for the appellant that the medical evidence runs contrary to the ocular evidence, since the doctor did not notice any sign of injection on the body of the deceased, and therefore the evidence of PW1 is to be discarded, is not acceptable, because the body was looking bluish, and the tongue was protruded and bluish, and the face was bluish, and more particularly when the after effects of the injection has been deposed to by PW1, and the recovery of exhibit A and B at the instance of the appellant, so also the viscera, indicates that one particular poison was found in all the three, and the ocular evidence has not at all been shaken. Relying on the evidence of the doctor regarding absence of any injection sign on the body of the deceased, we cannot discard the other evidence available on record against the appellant. Law is well settled that as held in case of Madan Gopal versus Nawal Dubey, reported in 1992, 3 Supreme Court cases 204.
I beg your pardon, my lord. Madan Gopal Kakkad.
Acha, Madan Gopal Kakkad versus Nawal Dubey.
And another.
And another versus Nawal Dubey, submitted by the Land Council for the state, that if the ocular evidence is clear, consistent, and trustworthy, and merely because the medical evidence runs contrary to the oral evidence, that cannot be a ground to discard the oral evidence. In view of the foregoing discussions, we find that the evidence of PW1, who is the wife of the appellant, is clear, clinching, trustworthy, and absolutely reliable, and her evidence that poisonous injection was administered to the deceased baby, for which there was reaction on the body of the deceased and she died, is not only getting corroboration from the external appearance of the deceased, which was noticed at the time of postmortem examination, but also the opinion given by the doctor, coupled with the C report that endosulfan insecticidal poison was detected in exhibits A, B, and in the viscera. No doubt, PW2 has stated that there was good understanding between the accused and PW1. The evidence has come on record that since the appellant was frequently remaining with his first wife at village Neherpal, the PW1 used to object it frequently. And moreover, in a absence of any motive, failure of the prosecution to prove motive in a case which is based on direct evidence is inconsequential. Therefore, the submission of the learned counsel for the appellant that since there was no motive on the part of the appellant to commit the crime, the prosecution case is to be discarded is not acceptable. In view of the foregoing discussions, the ocular evidence of PW1, the medical evidence adduced by PW4, the C report finding, the recovery of the syringe and plastic diba containing poison, which was administered to the deceased as per the C report, at the instance of the appellant, we are of the view that the Lenin trial court has rightly found the appellant guilty under section 302 of the Indian Penal Code. Accordingly, the jail criminal appeal being devoid of merit stands dismissed. It appears that the appellant was granted bail by this court on 17/6/2014. He shall surrender to custody within a period of 2 weeks from now or from today, failing which the Lenin trial court shall take appropriate steps for the arrest of the appellant for undergoing this sentence as awarded by the Lenin trial court, which is confirmed by us. Put a note of appreciation on the efforts of both the Lenin counsel for the appellant as well as Lenin counsel for the state. Fifteen disposed of us with honest.
The matter listed twice, thrice. The time of hearing, it's in that the paperwork is not in order. Directed to file the paperwork in proper forum, and already we filed before 6 months. It is the matter of 15.
You have filed the paper book.
Already filed.
You want for hearing of that criminal appeal.
Yes. He is a
2015.
employee. Applicant is a applicant is a employee. So kindly.
It's a vigilance matter.
My lord?
Vigilance matter. It's a case of conviction, na?
No, my lord. In 302, 304B रे ହେଇଥିଲା.
304B.
ଆଜ୍ଞା.
So paper book, if it is on order, then it can be just
Already paperwork ଆମେ ଦେଇ ଦେଇଛୁ.
Right.
ଠିକ.
let's give it.
Bail matter was listed on 5-1. Earlier matter,
Give it.
principal accused had been reliable.
Give it. Yes.
Lordship, this is specific urgent bail matter. My lord, on specific relevant, specific urgent.
Pardon to mention, your lordship, this is the BLAPL number 5317 of 2023, lordship. Accused is in custody from 4 years, lordship. His wife is suffering pelvic inflammatory disease, lordship.
Next details.
My lord, this is a mention for bail.
Here we go.
Pledged, my lord. Mention for bail, my lord.
My lord, pattern to mention CRLA 839 of 2023. The matter has been listed on 18/12/23, but could not able to reach the item number.
For what purpose you are mentioning? What is that CRLA for?
CRLA for bail and for stay pen.
Yeah.
Pledged.
18 is a internal report was called for.
Item 18. Yes. Interim bail means on what ground you are seeking?
Stage for suffering for stage for kidney failure, malor, cancer, malor.
That report has obtained. All right, you wait after the election petition is over. Yes.
Supplementary list, item number 21.
May I please, your lordships. Yesterday, I was placing Krishnamurthy's case, my lords. That case also relates to non-disclosure of criminal antecedents. Lordships may go through the entire. That judgment, my lords, covers up the entire development of the law. Plus, it says misinformation, no information, disinformation, half information, everything is fatal to the election petitioner. I mean, the respondent. And, my lords, I'm citing certain other cases where, my lords, the Supreme Court has set aside, High Court has set aside the election of the respondent, and the Supreme Court has upheld this, the judgments of the High Court. The first is 2014 SCC, page 160.
On what ground it was the
False information.
For false information.
Okay.
My lords, he had not given the educational qualification was BA, he wrote MBA. So he said stand was taken, it was a typographical error. Supreme Court said nothing. High Court set aside the election on that ground. Supreme Court upheld this.
What is the citation?
2014 SCC, page 162.
2014 SCC,
page 162.
162. What is the name of the party?
Kishan Shankar Kathor. Page 167, para 2.
What is the relevant paragraph?
My lords, paragraph 2, 31, 32, 34, 36, 37, 41, 43.
You want to place any particular paragraph?
My lords,
not necessary.
para 2, I'm just reading out para 2.
That is the sole ground. That
is the only ground.
That is the only ground.
BA jagare MBA.
BA jagare MBA लिखित. And they said it's a typographical error. Clerical error.
Please show that paragraph 2 re puti factual aspect.
Factual aspect आगे हला. Para 2 re The election petition was filed under section 101D1 and 4 of on the ground that in the nomination form filled in by the appellant, he had suppressed his dues payable to the government, suppressed the assets of his spouse, and also suppressed the information and assets of a partnership firm of which he is a partner. The appellant contested the said petition. Evidence was led after hearing the arguments. The High Court passed judgment accepting the plea of the first respondent that the nomination form of the appellant was defective and should not have been accepted by the returning officer. Thus, while allowing the election petition and setting aside of the election of the appellant, the High Court recorded the non-disclosure in following grounds.
ଏଇଟା
Not
କୋଉଠି
disclosure.
ସେଗୁଡା ଅଛି ମୋ ଏଜୁକେଶନାଲ କ୍ୱାଲିଫିକେସନ ତ ଏଇଟା
ନା ନା ଏଇଟା ଏଜୁକେଶନାଲ କ୍ୱାଲିଫିକେସନ ନା ନା ଏଇଟା ନୁହେଁ ଆଜ୍ଞା
ମୁଁ ଲେଖି ସାରିଲିଣି ଆପଣ
ଏଇଟା ହେଲା ଏଇଟା ଆଇ ଏମ୍ ସରି ମାଲୋଜ ଏଇଟାରେ ହେଲା
2017 to SCC.
ଆପଣ ଏଇ ମୁଁ ଆପଣ
ନା ନା
ପଚାରିଲି
ଏଇଟା କିशन ସିଂ କାଠୋର was suppression of ମାଲୋଜ his assets.
this all right.
I am sorry ମାଲୋଜ ସେ ସବୁ ଜଜମେଣ୍ଟ ସେ ହେଲା ବେଳକୁ
ଏଇ ଯୋଉ ପାରାଗ୍ରାଫ ଗୁଡା କହିଛନ୍ତି ସେଗୁଡା ଠିକ ତ
ଆଜ୍ଞା ସେଗୁଡା ସବୁ ଠିକ ଅଛି 179 ରେ ସେ କହିଲେ non disclosure of page 179 ରେ non-disclosure of bungalow 866 in the name of spouse and outstanding taxes thereof. Then again, non-disclosure of vehicle number MHAC 555 owned by the appellant's wife. Tapare 31, 32 issue frame hala. That takes me to the next issue, 31. On issue number 7, finding of the High Court, page 183. Right?
So, one thing I would request to both of you that while preparing the note, suppose on one particular point, let us say 5 issues are there. So that 5 issues you also answered at one stage that is, and
Yes.
I will request Mr. Mishra so that at least ଗୋଟେ ଆପଣ ଯଦି ପାସନ ହେଇଯାଆନ୍ତା ମାନେ ରିଟିନ୍ ନୋଟ୍ ପରେ ପଛେ ଏଇ ଇସ୍ୟୁ ଗୁଡାକ ଆମେ ଜଏଣ୍ଟଲି ଗୋଟେ ଇଏରେ ଡିଲ୍ କରିବା ତାହେଲେ ସେଇ ଇସ୍ୟୁଟାକୁ ନେଇକିନି ଆପଣଙ୍କର ଆର୍ଗୁମେଣ୍ଟ କଣ ତାଙ୍କର ଆର୍ଗୁମେଣ୍ଟ କଣ in short just a paragraph and then I will give my finding. That would be easier because if we deal only 2 issues at one point of time and 3 issues at that and they will jointly discuss in that those 5 issues under one heading that may create some kind of
confusion.
Not confusion but it is
ଆମେ ଆଜ୍ଞା ଯୋଉ ଇସ୍ୟୁ ଆପଣଙ୍କୁ ଡାକୁଛୁ ସେଇ ଇସ୍ୟୁରେ ଗୋଟିଏ ସାଙ୍ଗରେ କରିଦବୁ
ମୁଁ କଣ କହୁଛି କି ଆପଣ ମାନଙ୍କର 5, 7, 8, 9, 10 ଏଇ 5ଟା ଇସ୍ୟୁ ଗୋଟେ ସାର୍ ମଧ୍ୟ ସେଇ ଦିଅନ୍ତୁ ଯେ ଆମେ ଏଇ ହେଡିଂ ରେ ଦଉଛୁ ଯଦି if it is possible then ଆପଣଙ୍କର ତାପରେ ଇଏ କଣ ତାଙ୍କର କଣ ଏଇଟା ହେଲେ I think that ହଁ ହଁ ସେଇଟା ହେଲେ ଇଜିୟର ଟିକେ ହବ ସେଇଥିପାଇଁ
Certainly.
yeah.
Issue 7 re finding of the High Court is nomination was improperly accepted by the returning officer by giving following reasons. That takes me to the next issue as to whether petitioner proves that the respondent's nomination form is improperly accepted by returning officer.
You are facing which paragraph?
My lords, paragraph 31, page 183. That takes me to the next on issue number 7. Finding of the High Court is that nomination was improperly accepted by RO by giving following reasons. That takes me to the next issue as to whether the petitioner proves that the respondent's nomination form is improperly accepted by RO. Insofar as this issue is concerned, the respondent may be right to the extent that the RO cannot be faulted for having accepted the nomination form of the respondent. That was required to be accepted in spite of the objection in view of the decision of the Apex Court in PUCL and the order issued by the Election Commission on the basis of the law declared in the said judgment, inasmuch as it was not open to the RO to inquire into contentious issues raised in this petition in the summary inquiry at the stage of scrutiny of nomination forms. Those matters necessarily have to be addressed only after it is disclosed in an inquiry upon taking evidence on the relevant facts at the trial of the election petition. This does not mean that the nomination of the respondent was proper and lawful. As the respondent's nomination paper suffered from defects already referred to in the earlier part of this decision, it is plainly a case of improper acceptance of his nomination paper by the RO covered by the rigors of 101D1 of the Act. So issue 7 will have to be answered accordingly. So, my lords, as also in Krishnamurti, no objections need be raised. Then, my lords, contentious issues the RO cannot add because it is in the nature of a summary inquiry. The actual inquiry, that is why I have been stating your lordships is also the inquiring officer. The actual inquiry takes place in the election petition. Your lordships will hear their side, our side, your lordships will hear their side, see the evidence on record, and then come to a finding which will revert back to the date of acceptance of nomination. 38 pertains to the question as to, then 32 is important, no? 33, 36. In view of the page 185. In view of the aforesaid, two facets of the issue which require consideration are as follows. Whether there is a substantial compliance in disclosing requisite information in the affidavits filed by the appellant along with the nomination paper, whether non-disclosure of information on account of the aforesaid four aspects has materially affected the result of the election. 37. We have already discussed in detail each item of non-disclosure as well as defense of the appellant pertaining thereto for the reasons recorded in detail at that stage by the High Court and stated above, with which we agree. We are of the opinion that its finding about non-disclosure of the information qua all the aspects is without blemish. There is a specific format in which the information is to be given, which was not adhered to. So the format has to be adhered to, my lords. Then, my lords, 41. It was argued acceptance of nomination is as per section 33 of the Act, which contains requirement for a valid nomination. Further, 36(2) deals with the rejection of nomination on grounds specified therein. It was the submission of the learned senior counsel that at the time of scrutiny of the nomination under section 36, nomination could be rejected only if any of the grounds stipulated in subsection 2 are satisfied, and there cannot be any deemed ground which is not covered by section 36(2) of the Act. Therefore, the RO had rightly accepted the nomination form as none of the grounds specified in subsection 2 of 36 were attracted. He further submitted, my lords, thereafter, your lordships may see 43 at running page 188. When the information is given by a candidate in the affidavit filed along with the nomination paper and objections are raised thereto questioning the correctness of the information or alleging that there is non-disclosure of certain important information, it may not be possible for the RO at that time to conduct a detailed examination. Summary inquiry may not suffice. The present case is itself an example which loudly demonstrates this. At the same time, it would not be possible for the returning officer to reject the nomination for want of verification about the allegations made by the objector. In such a case, when ultimately it is proved that it was a case of non-disclosure and either the affidavit was false or it did not contain complete information leading to suppression, it can be held that at that stage nomination was improperly accepted. Meenakshi Arora, learned senior counsel appearing for the hearing, rightly argued that such an inquiry can only be at a later stage, and the appropriate stage would be an election petition, as in the instant case when the election is challenged. The grounds stated in section 36(2) are those which can be examined there and then, and on that basis, RO would be in a position to reject the nomination. Likewise, where the blanks are left in an affidavit, nomination can be rejected there and then. In other cases where detailed inquiry is needed, it would depend upon the outcome thereof in an election petition as to whether the nomination was properly accepted or not, as it was a case of improper acceptance. Once it is found that it was a case of improper acceptance, as there was misinformation or suppression of material information, one can state that question of rejection in such a case was only deferred to to a later date. When the court gives such a finding, which would have resulted in rejection, This effect would be same, namely, such a candidate was not entitled to contest and the election is void. Otherwise, it would be an anomalous situation that even when criminal proceedings under 155A of the Act can be initiated and the selected candidate is criminally prosecuted and convicted, but the result of his election cannot be questioned. This cannot be countenanced. Ultimately, Mallots, the upshot of the aforesaid discussion would be to hold that the present appeal is totally devoid of any merits, accordingly dismissed. Here there was non-disclosure of the bungalow of his wife and a motor vehicle. The next judgment that I'm citing,
Yes.
the next 2017 2 SCC page 487. Marambam Prithviraj versus Pukram, Sharat Chandra Singh. Here, this is the citation. Educational. Para 2.
2, 8, 9, 10, 13, 17, 19, 23, 26.
Please. Notification was issued for election to the 10th Manipur Legislative Assembly. The appellant belonging to NCP and the respondent who was sponsored by INC filed the nominations within prescribed time. There was no other nomination filed. Respondent objected to the nomination of the appellant at the time of scrutiny on the ground that it is a false declaration relating to educational qualification made by the appellant. The RO directed the appellant to submit documents in proof of his educational qualification as declared in the affidavit filed under Form 26. The appellant failed to produce any document to prove his educational qualification, in spite of which the returning officer accepted the nomination of the appellant. Polling took place and counting of votes there after para 8 at page
495.
495. Two issues fall for our consideration in this appeal, which are whether a false declaration relating to educational qualification is a defect of substantial character warranting rejection of a nomination, whether it is necessary to prove and plead and prove that the result was materially affected when the nomination of the returned candidate was found to have been improperly accepted, more so when there are only two candidates contesting the election. Then the sections have been quoted, my lords. Scrutiny of nomination, ground for disqualification, 100. Your lordships may straight away come to para 13, 497. This is the principle why all the courts say that the voter has to be informed. This is a principle led by Sir Winston Churchill. Sir Winston Churchill, underlining the importance of a voter in a democratic form of government, stated as follows: at the bottom of all tributes paid to democracy is the little man walking into a little booth with a little pencil, making a little cross on a little bit of paper. No amount of rhetoric or voluminous discussion can possibly diminish the overwhelming importance of the point. So this little man, when he makes his choice, should be an informed choice. 17, my lords. Yes. It is clear from the law laid down by this court as stated that every voter has a fundamental right to know about the educational qualification of candidate. It is also clear from the provisions of the Act, the rules, and Form 26 that there is a duty cast on the candidates to give correct information about their educational qualifications. It is not in dispute that the appellant did not study MBA in the Mysore University. It is the case of the appellant that reference to MBA from Mysore University was a clerical error. It was contended by the appellant that he always thought of doing MBA by correspondence course from Mysore University, but actually he did not do the course. So here also he takes the stand that it's a clerical error. Then para 19. The finding. The contention of the appellant that the declaration relating to his educational qualification in the affidavit is a clerical error cannot be accepted. It is not an error committed once. Since 2008, the appellant was making the statement that he has an MBA degree. The information provided by him would amount to a false declaration. Then para 23. At page 503. They have quoted Durai Swami's judgment and para 23, it is clear from the above judgment in Durai Muthuswamy that there is a difference between the improper acceptance of a nomination of a returned candidate and the improper acceptance of nomination of any other candidate. There is also a difference between cases where there are only two candidates in the fray and a situation where there are more than two candidates contesting the election. If the nomination of a candidate other than the returned candidate is found to have been properly accepted, it is essential that the election petitioner has to prove and plead and prove that the votes polled in favor of such candidate would have been polled in his favor. On the other hand, if the improper acceptance of nomination is of the returned candidate, there is no necessity of proof that the election has been materially affected, as the returned candidate would not have been able to contest the election if his nomination was not accepted. It is not necessary for the respondent to prove that result of the election insofar as it concerns the returned candidate has been materially affected by the improper acceptance of his nomination, as there were only two candidates contesting the election, and if the appellant's nomination is declared to have been improperly accepted, his election would have to be set aside without any further inquiry, and the only candidate left in the fray is entitled to be declared to be elected. Set a second portion there, Dijon Thelevali is entitled to be declared. So if the returned candidate, the nomination is declared illegal, void, then there is no necessity of even pleading that it has materially affected the election, which we have pleaded. It is not that we have not pleaded, we have pleaded everywhere. Then, my lords, your lordships may see page 504. They quote Kishan Singh Kathor, जोटा मैं प्लेस कर लूं, para 26. Para 26, once it is para 26 upare 43, they have quoted from Kishan Singh Kathor quote karchanti. Once it is found that it was a case of
26, it starts with
mere finding. Like ta upar hai 43 is a quote, is a passage from Kishan Singh.
I said improper acceptance.
Once it is found that it was a case of improper acceptance, as there was misinformation or suppression of material information, one can state that question of rejection in such a case was only deferred to a later date. When the court gives such a finding, which would have resulted in rejection, the effect would be the same, namely such a candidate was not entitled to contest the election and the election is void. Then mere finding that there has been an improper acceptance of the nomination is not sufficient for a declaration that the election is void under 101D. There has to be further pleading and proof that the result of the election was materially affected, but there would be no necessity of any proof in the event of the nomination of a returned candidate being declared as having been properly accepted, especially in a case where there are only two candidates in a fray. It is say that if the returned candidate's nomination is declared to have been improperly accepted, it would mean that he could not have contested the election, and that the result of the election of the returned candidate was materially affected need not be proved further. We do not find substance in the submission of Mr. Giri that the judgment in Durai Muthuswamy is not applicable to the facts of this case. The submission that there is a case of disqualification under 9A of the Act, and so it is not applicable to the facts of this case is also not correct. As stated supra, the election petition in that case was rejected on the ground of non-compliance with 101D. The said judgment squarely applies to this case on all fours. We also do not find force in the submission that the Act has to be strictly construed and the election cannot be declared. Ultimately, my lords, they have dismissed the appeal. So, my lords, the sum and substance of this case, they have followed Kishan Singh Kathor and said that once the returned candidate's nomination has been declared to be illegal void, then there is no further necessity of pleading further that this results in material, my lords, yea.
Only one case was not disclosed.
Here, this is at a Patna.
145 percent
Here, my lords,
citation.
citation is
2016 February PLJR.
এটা মনুরা দিয়ে দিচ্ছি হ্যাঁ পাটিনালা গঙ্গা মিশ্রা versus Chedi, CHHEDI. Paswan. Huh? Manurala Manu stroke BH stroke 0533 stroke 2016. Huh? Patna. এটি আগে
the return candidate. Last 4 lines.
Your lordships may come to page 3 of the decision, my lords. Paragraph 4 ঠিক উপরে
Page mark তলে আছে left side.
পেজ মার্কটা তলে হয়েছে
Just 4 lines.
Just fourth line.
Paragraph 4
upare aage. The returned candidate, your lordship gets it? The returned candidate in clause 5 of form 26 filled up by him did not record pendency of Mohania PS case number 168 of 2006. His nomination paper was liable to be rejected. The RO illegal improperly accepted the nomination paper of the respondent, returned candidate. In clause 5.2 of form 26, returned candidate wrote nil. This is clear case of suppression of his criminal antecedents. Thereafter, para 8. Next page again. Page 4. Para 8. The counsel for respondent number 1 has opposed the application and the prayer made therein. It is submitted that according to prescribed form, in paragraph 5.2 thereof, the respondent was not required to give information of Mohania PS case number 168 of 2006 because the charges in the said case had not been framed against him till date of filing of the nomination paper. And even today by competent court in which the punishment is imprisonment for 2 years or more. It was the duty of the ECI to publicize the new format to collect information regarding criminal cases pending against contesting candidate in which charge sheet was filed by the police against the candidate and cognizance taken by the competent court. Unfortunately, ECI did not publicize the new format requiring candidate to give detailed relevant facts. There was no space provided in Form 26 to provide such information. such information. While information sought in paragraph 5 of Form 26, the candidate was required to enlist only cases pending against the candidate in which the imprisonment is 2 years or more and charges have been framed by the. This is under the. My lords, I'll pause here for a moment, my lords. This is under the old form. New form, any case, your lordship, I'll take your lordships to the form. All cases you have to mention. If it is so, then only the candidate filling up the affidavit has to proceed further with subpara 1 and 2 of para 5 of Form 26. Otherwise, the contesting candidate is not required to answer subpara 1, 2 of Form 20. In these circumstances, the respondent number 1 quite bona fidely filled up the relevant column as shunya, as indisputably no charge was framed in those cases against the petitioner in which the imprisonment is 2 years or more. The details required to be furnished in subpara 2 of para 5 of Form 26, if read carefully, would clarify these facts. It is clearly written in the bracket of subpara 2 other than the cases mentioned in item number 1 above. It is thus more than obvious that if the contesting candidate has furnished relevant information in subpara 1, which required detailing of the case in which candidate is accused of any offense in which punishment is 2 years or more and the charges has been framed by the competent court, then only the respondent number 1 was obliged to set out details information in subpara 1 of para 5 as to whether he has got any other pending criminal cases. The respondent number 1 is accused in 3 cases which are trivial in nature. Out of them, 2 cases relating to pasting of posters on the wall without consent during elections held in 2005, in which the imprisonment is up to 6 months. In one of those 2 cases, namely Mohania PS case number such and such, the respondent has been acquitted by the court. The third case, registered in year 2006, was also trivial, as on account of staging peaceful dharna on the roadside of GT Road, Mohania, in order to pressurize the government to take up and commission the Durgavati project meant for providing irrigation facilities to the agricultural lands of more than 2 lakh farmers of 34 Sasaran SC parliamentary constituency. The same was lodged. It is the political right of the citizens in active politics to do so for the benefit of the people of the constituency. The said project has now been commenced. In the above case registered under 145 IPC, besides other penal provisions, the punishment provided is up to 2 years. Hence, under legal advice and considering the requirements of aforesaid paragraph of Form 26, the respondent number 1 had not disclosed the case of the in Form 26. The manner in which Form 26 required detailing of the criminal cases pending against the candidate, filling up the form affidavit in which the punishment provided was up to 2 years, prevented him to enlist the said case. Further, as no charge was framed against the respondent number 1 in the said case, also prevented him from enlisting the said case in Form 26. It was not a case of deliberate suppression of relevant facts with a view to deny the electors of his right to know criminal antecedents of the candidate contesting the election. Then your lordships may turn to para 13. Next page. Lordship gets it. Next
For
page.
better appreciation.
Page 6, Raj.
Issue
Para
number
30.
7.
Issue number 7. For better appreciation of the case, this case is taken up. This issue is taken up for consideration out of turn. The election petition in para 22 has asserted that non-compliance of the Constitution and the provisions of the Act and the rules and the orders made thereunder, the election of the returned candidate is fit to be declared void insofar as it concerns the returned candidate, as the election on account of illegal acceptance of the nomination paper filed by the returned candidate has materially affected the election. In case the court holds the nomination paper submitted by the returned candidate was illegally or improperly accepted, then the election of the returned candidate is bound to be declared as void. Naturally, it would amount to materially affecting the result of the returned candidate. Though not much submission has been advanced on this issue by respondent number 1, returned candidate, yet this court would note that in the case of Krishnamurthy versus Shiv Kumar and others, 2015 ARSCW যেটা আমি cite করছি. In paragraph 86C, the apex court observed that in a case like this, the question whether it materially affects the election or not will not arise. Consequently, the court has no difficulty to conclude that in case the court accepts the contention of the election petitioner on the main issues, then the result of the elections can be held to have been materially affected. No further discussion in the light of the pleadings and the evidence issued in support thereof required to be noticed with a view to amplify the point issued. My lords, then para 14, mm, these issues are genetically interlinked and have been considered together. There is also agreement at bar that they are interlinked, and the crucial issues falling for consideration in the election petition which shall determine the fate of the election petition. Relevant pleadings in this regard have been made in paragraph 7 to 16 of the election petition. Before the court notices that oral evidence adduced by the parties on these issues, it is apt to notice the documents exhibits available on record in these issues. Exhibit A series एगुरा script कर जेबे
There is no denial.
शून्य नील जोठी लेखा आइछि तापर your lordships में kindness. There is no denial.
Yes.
There is no denial of the case of the election petitioner that during the relevant time, 3 criminal cases were pending in court against the respondent number 1, out of which one case being Mohania PS case number Ete was lodged on amongst others under section 145, wherein punishment provided is 2 years. Exhibit C series is Annexure 5 series of the election petition, which is the entire order sheet of Mohania PS case number 168 of 2. On perusal of the order sheet, it appears charge sheet was submitted in the said case on August 7, 2007 under sections 143-45 of the IPC, whereafter cognizance was taken by the learned CJ Bhabua. The respondent number 1 in the case surrendered in court and was granted bail on 19/2/2010. Exhibit D are similarly the entire order sheets of Mohania PS case number respectively was cited as accused for having committed trivial offences relating to election in which punishment provided is lesser. They are not material for adjudication of the issues as put up by the election petitioner. But entire evidence को से देखिले para 29
Last but one page.
last but one page. Lordship gets it. 29. The ECI issued guidelines to contesting candidates as well as RO on 1st August 2012, in which Association for Democratic Reforms and PUCL judgments were required to be complied with. Form 26 as given in the Act is on record. Copies of the handbook of the candidate as well as for the RO has been produced in course of argument for perusal of the court. As noticed, RO respondent number 1 filled up the relevant paragraph of Form 26 as shunya, nil. The word constitution used in 101D5 of the Act is generic, purpose oriented, and cannot be controlled by the provisions of the Constitution enumerated in Section 36 of the Act. There has been infraction of the requirements of law as directed by Honorable Supreme Court in the judgments referred to above at the hands of respondent number 1. I have further concluded that it is found so that the election of respondent number 1 34 Sasaram SC Parliamentary Constitution held in 2014 is fit to be declared void, as the respondent number 1 shall be held to have exercised undue influence during the course of said election, which is a corrupt practice within the meaning of the Act. It has been strenuously submitted on behalf of the respondent number 1 that Mohania PS case number was instituted under minor sections of the Penal Code, which include 145 in relating to staging of dharna or blocking of the road for immediate implementation of a water project in the constituency for the benefit of the people voters at large. It is one of the rights of a citizen who is in active politics to do so. Triviality of the offence in which the contesting candidate is involved, in my view, would not be of much consequence. A contesting candidate, according to the requirements of law, is mandated to disclose his past criminal antecedents where the possible conviction is 2 years or more. The punishment provided for the offence to be disclosed as the antecedent itself suggests that the contesting candidate may have serious offences registered against him in which either cognizance has been taken or charges framed, yet the law mandates for disclosure thereof. In Association for Democratic Reforms, reinforced in PUCL, the Apex Court found the elector's right to know the antecedent of a contesting candidate as a facet of right to freedom of speech and expression enshrined in Article 19(1)(a) of the Constitution. What has been held in Association for Democratic Reforms is that the contesting candidate must disclose in relevant form on affidavit the criminal cases instituted against the contesting candidate prior to 6 months of filing of nomination as to whether the candidate is accused in any pending case of any offense punishable with imprisonment with 2 years or more of any offense, and in which charge is framed or cognizance is taken by the court of law. It is in this context paragraph 5.1.2 of Form 26 can be seen and appreciated. Indisputably, cognizance of the case taken by competent court of law was taken in Mohonia PS case number such and such. In fact, the respondent had disclosed the pendency of the aforesaid case while filing his nomination paper to contest 204 Mohonia. The same was, however, not disclosed to contest the present election. In the circumstances for such non-compliance of the provisions of the Act, the order issued by the ECI under 324 of the Constitution and breach of 91A of the Constitution, the election respondent 1 to 4 is liable to be held to be void, declared void, as it suffers from constitutional disability. 28/7/2016.
Two issues. Schedule caste, one khata property not disclosed.
Well, this is a judgment of the Orissa High Court. It is Sahadev Khakha versus Jogesh Singh and others. Election petition 20 of 2014. I have page 3 re, last paragraph re, regarding the contentions. The main issues here was, first is he did not belong to the scheduled caste, and the second ground that was taken is that he has disclosed his properties under one khata. Page 3 ର ତଳେ. For the plea of the petitioner, for the plea of the petitioner in election petition 20 of is the respondent number 1 along with his nomination filed affidavit in form 26 as required under section 33 of the RP Act, and in such affidavit he concealed the details of his spouse and dependents. He has not filled up the pro forma in form 26 prescribed by election commission, wherein he is required to state the name and address of his spouse and defendants, and concealed his immovable property under Khata 207 of Mozas Sargipali and Khata number 75 of village Sagjori, and as such he has violated the mandatory requirement of law. For such violation, the returning officer should have rejected the nomination paper of respondent number 1, but he has improperly accepted the same, though it was required to be rejected. Then your lordships may turn to page 9 of the judgment. Para 8. Certificate Order 7, Rule 11 application was moved on the maintainability of the election petition, heard extensively and dismissed. So issues number 2 and 3. Issues number 2 and 3, whether the election petition is hit by section 86 of the RP Act and whether there is cause of action. These issues were preliminary raised by respondent number 1 by filing miscase number such and such in election petition. In his petitions filed under Order 6, Rule 16 and Order 7, Rule 11 of the Code of Civil Procedure, praying for rejection of the election petitions on the ground that the petitions do not disclose any cause of action as per the pleadings in the election election petitions with further prayer to strike out the pleadings in certain paragraphs of the election petitions. Both those miscases were disposed of by order dated 28/10/2016 by rejecting the miscases with the finding that the pleadings in the election petitions do disclose cause of action and that the election petitions are not hit by Section 86 of the RP Act. The orders passed in the miscase by this court were challenged by respondent number 1 before the Honorable Supreme Court in civil appeals number such and such, and both the civil appeals were dismissed with a direction to conclude the trial of the election petition within a stipulated time. In view of the aforesaid, it is not necessary to further delve into these issues.
Page 24.
My lords, similarly here, they have been arguing that this has not been stated, this should have been stated, this has not been incorporated. Your lordships have already held. All material facts have been stated which constitute a cause of action which has been upheld by the Supreme Court. So that concludes the matter. Then your lordships will see page 24.
First issue is the right, I mean,
First issuta was not accepted.
88,
Issue 4, 5 and 7.
24.
Para 24.
Yes.
Page 24, para 24. Issues number 4 and 5 relate to the questions whether respondent number 1 concealed the details of his spouse and dependents in the affidavit filed in Form 26, accompanying his nomination paper, and also suppressed his immovable properties pertaining to Khata 207 of village Sargipalli and Khata number 75 of village Sagjori. Then last, towards the subpara, Exhibit 24. Next, when a subpara, the affidavit in Form 26 filed by respondent number 1 indicates that there is no mention of the names and other particulars of his wife and other dependents, though in his evidence he has admitted that he has a wife, one son and one daughter. Similarly, in the affidavit, there is no mention of his properties pertaining to Khata number 2, the Sat and Khata number 75 of village Sagjuri. He, however, volunteered Khata number 207 is the property which had already been sold by his father, but no sale deed was produced, nor was he able to state the date of sale. On the other hand, that he admitted that ROR of Khata 207 before the Tahsildar Lahripara, along with the application for issue of caste certificate in the along with in the year 2014. He also admitted that he has paid land revenue by receipt Exhibit 2B in respect of the land covered under that khata. He also admitted that he has not mentioned in his affidavit about his property under khata number 75 of Moza Sagjori. It is also admitted by respondent number 1 in evidence that in his affidavit in Form 26, he has suppressed the name and other particulars of his spouse and children and his properties covered under the said two holdings khatas. Page 29. Then this honorable court again follows all the judgments we have referred to, including Kishan Singh Kator. 29. Page 29, para 29. In view of the law, Lordship gets it.
Yes.
In view of the law laid down in the said judgments and keeping in view the admitted facts that respondent number 1 suppressed names and other particulars of his spouse and other dependents and his immovable properties under two holdings, the suppression was of substantial character and as such his nomination was liable to be rejected. Since his nomination did not deserve acceptance, he would not have been able to contest the election and the vote secured by him would have gone to any other candidate or candidates. Therefore, the improper acceptance of his nomination for suppression of material information in the affidavit, the result of election has been materially affected. Therefore, the election of respondent number 1 to 9 Sundargarh ST Assembly must be declared to be void and liable to be set aside. Ultimately, my lords, the election petition was set aside. This was also challenged in the Supreme Court. And they are, we have also given the last page of the order, my lords. It was challenged in appeal. The Supreme Court also did not grant stay, but later on, my lords, he changed his party. He resigned. He resigned and changed his party.
Argument has been made, so actually passing the judgment, it will stay till appeal is filed. But no, Supreme Court even appeal, no High Court has even stayed, Supreme Court also refused.
এটা গলা সুপ্রিম কোর্ট
The last ଲାଗିଛି ସେ ଆଗ judgment ସାଙ୍ଗରେ. Last page, Supreme Court Civil Appeal number 1803 of 2018.
Order passed was issue notice in the appeals as also in the applications for stay. In the meantime, petitioner shall be entitled to attend and participate in the proceedings of the Legislative Assembly. However, he shall not have right to vote. So they did not even stay this application, this order. Thereafter, my lords, Jogesh Singh has withdrawn this appeal. That order also we have given. As produced issued by the Secretariat. As per this notification, appellant has resigned the seat in Orissa Legislative Assembly and his resignation has been accepted since he is no more than an MLA. The learned counsel fairly states that this appeal has become infructuous. So, my lords, this judgment holds good.
Why it has been held in page number 30.
My lords,
Casual vacancy to the said constituency has offered. I think usually direction is given to hold the
to hold the re-election 6 months till re-election.
ଏଇଠି ନଥିଲା
ନଥିଲା
No.
ଏଠି ବି ନଥିଲା
He was
similar
conducting.
situation
ମାନେ ମୁଁ ସେଇଥିପାଇଁ
ଏଠି ବି similar situation ଆମର ଏ present case ରେ ଏଠି ବି 6 ମାସ ଉପରେ
ପଚାରିଲି ଯେ କଣ ପାଇଁ casual vacancy କରାଗଲା
ଆଜ୍ଞା.
right
ଏଠି ବି ନଥିଲା and while passing the judgment High Court has not stayed the order as an submission was made by my senior that at the time of passing judgment your lordship can stay the judgment till appeal is filed. But to my knowledge, my lord, no court has ever stayed their own judgment.
No, that's it. But here Mr. Kanungar, this judgment was pronounced on 31/2018.
Yes.
You said that 6 months was not there, but I think election was held in April 2019.
Notification ହେଇଗଲା ଇଏରେ. Yes.
ଏଇ କେସ୍
6 ମାସର ବର୍ଷେ 6 ମାସ ବି ଆଜ୍ଞା ବର୍ଷେ ଭିତରେ ଯଦି ହବାର ଥବ ତାହେଲେ ବାଇ ଇଲେକ୍ସନ 1 year.
ମାସ ନା ମୁଁ ସେଇଥିପାଇଁ
1 year
it is 1 year.
1 year ରୁ ଯଦି କମ ଥବ ହବନି.
କାରଣ notification ତା ଆଗରୁ ହେଇଯାଇ ପାଇଁ.
And even appeal, Honorable Apex Court has not stayed this order. Honorable Apex Court allowed him to participate in the house, but he has no right to vote.
Now, my lords,
ଏଇଟା ଶୁଣ ଏଇ ଯୋଉଟା ଦେଲେ ପଛରେ just ଗୋଟେ ଛୋଟ ଷ୍ଟାପ୍ଟରରେ ମାରିବେ. Yes.
I take your lordships to the facts of this case. How he has suppressed, given misinformation, given false information, suppressed the actual sections in which he has been implicated. पूरा note करके रख.
Criminal
criminal cases आगे हमें note करके अपन को note टा दोची so that it will be. No, it has sir. Your lordships will kind
13 cases he has given
13 cases ଦେଇଛନ୍ତି.
Yes.
କିନ୍ତୁ 13 cases ରେ ସବୁ ଜାଗାରେ ଭୁଲ information ଦେଇଛନ୍ତି, misinformation ଦେଇଛନ୍ତି, false information ଦେଇଛନ୍ତି. ଆଜ୍ଞା. Election petitioner in para 7C, your lordships में para 7C has pleaded respondent in his affidavit dated 3/4/2019.
Just
lordships में see the election petition
7-0 को paragraph कौन तो
7C
page 10
page 10.
Yes.
That the respondent in his affidavit dated 3/4/2019 filed along with his nomination paper on 2/4/2019 has falsely and deliberately not made correct, proper, and full declaration about the details of the criminal cases pending against him.
Right.
The respondent has not accurately mentioned correct fact under column 5 of the affidavit submitted by him before the returning officer as to whether any criminal case was pending against him or not. In column 5 2A, the respondent has mentioned FIR number 136 136 by 2012 dated 24/9/2012 in Balyanta police station, Cuttack, Odisha, whereas there is no Balyanta police station in the district of Cuttack. Similarly, respondent has mentioned FIR number 34 dated 6/9/2007 Vigilance Police Station, Cuttack, Odisha, whereas there is no FIR number 34 dated 6/9/2007 in Vigilance Case Police Station, Cuttack, Odisha against the respondent. The respondents has not disclosed about the pendency of FIR VGR number 34 dated 6/9/2007 of Vigilance Police Station, Bhubaneswar, Odisha against him. The respondent has also not disclosed the FIR VGR number of the TR number 41 of 2013 pending in the Court of Special Judge Vigilance, Bhubaneswar against him and others. Similarly, the declaration made in column 5 2B, serial number 9 by the respondent about the GR case number 680 of 2012 in the court of SDGM Bhubaneswar is false and a misleading declaration. There is no GR case number 680 2012 pending against the respondent in the court of SDGM Bhubaneswar. Rather, a GR case number 680 of 2012 is pending against the respondent in the court of JMFCO Bhubaneswar. Right from the beginning, it is in the court of the JMFCO. It is not that it has been transferred or anything. Further, the FIR numbers given in column 5.2a and the corresponding case numbers and the name of the court declared in 5.2b and sections of the concerned act codes involved are false and misleading declarations. The respondent in column 5.2d has declared that two charges relating to wrongful restraint, IPC section 341, whereas in column 5.2c 5 to C serial number 5 and 6 and 12, he has declared 3 cases under section 341 of the IPC is pending against him. The respondent
এইটাকে prove করে we exhibited all the FIR.
ঠিক আছে এটা স্যার দিন হ্যাঁ Then the respondent in column 5 2D has declared that two charges relating to obscene acts and songs, IPC 294, whereas in column 5 2C serial number 1 2 3 4 5 6 and 12 he has declared 6 cases under section 294 of the IPC is pending against him. Similarly, the respondent in column 5 2D has declared 5 charges related to cheating and dishonestly inducing delivery of property, IPC section 420, whereas in column 5 2C serial number 5 3 6 7 to 10 and 13 he has declared 6 cases under section 420 of the IPC is pending against him. The respondent in column 5 2D has declared 5 charges relating to punishment of criminal conspiracy, IPC 120B, whereas in column 5 2C serial numbers 3 7 to 10 and 13 he has declared 6 cases under section 120B of the IPC is pending against him. The respondent in column 5 2D has declared 2 charges related to mischief by injury to public road, bridge, river, channel, IPC 143, whereas in column 5 2C serial number 1 4 and 5 he has declared 3 cases under section 143 of the IPC is pending against him. The respondent in column number 5 2D has declared 2 charges related to mischief by doing any act in respect of any public property, sections 7/3 and 7/4 of PDPP Act, whereas in column 5 2C serial numbers 1 to 12 1 2 and 12 he has declared 3 cases under the PDPP Act. The respondent in column 5 2C serial number 3 7 to 10 and 13 has declared about cases pending against him under section 13(2) read with 13(1)(d) of the PC Act 1988 but has not declared about the same in column 5(2)(d) of the affidavit. My lords, in for 5(2)(d) he does not even state anything about vigilance cases pending against him. Thus, the respondent has made false declaration about the pendency of criminal cases against him. Non-disclosure of criminal cases by the respondent in entirety and in full detail in the prescribed Form 26 as mandated under Section 33A of RP Act, read with Rule 4A of the Conduct of Election Rules 1961, creates impediment in free exercise of electoral rights by the voters. Therefore, the election of the respondent from 90 Barabati constituency is to be declared null and void, as misinformed voters could not make an informed choice according to their free will and conscience, and the same violates the fundamental rights of the voters to know.
Then para 7G.
Then para 7G,
At page
Chief,
16.
at page 16.
Just to go through.
My lords,
Just 1 minute.
I'm sorry. I'm sorry.
Just one thing, it struck to me, it is also for Mr. Mishra. And I think he has taken a ground that since I am not a public servant and it relates to a PC Act matter, so I have not mentioned that. That is the ground.
Yes, my lords is taken.
But there are some decision of the Honorable Supreme Court that a non-public servant can also be prosecuted under PC Act
Yes,
if he has got conspiracy with the public servant
Conspiracy.
to commit the crime.
120 beta attract.
See light ray.
Ah.
So
one column of disclose.
not only he has omitted that offense, that
Vigilance.
PC Act, on the ground that I am not a public servant, I am not supposed, but he can be prosecuted with aid of 120B. That this Supreme Court decision that Nalla Mal case. So, sir.
Se amor pleading, upon plead koche. Sir, kintu he himself discloses in the FIR that he is an accused of the in the affidavit that he.
The reason they have said that why you have omitted, I think that was the question put.
Yes.
Why have you omitted PC Act?
Yes, my lords.
He said that I am not a public servant, so that's why.
Lord, may I clarify? In
FIR.
one column, he discloses that under a PC Act cases are pending. Your lordship kindly see exhibit.
Somewhere he has left it out.
In other column, he has left it.
The reason he has given.
Given that I am not a public, so a question was put: if you are not a public servant, why you disclose in other column? Why not here? And if your lordship looks to the newspaper publication made by him, he discloses that cases under PC Act are pending against me.
Oh yes, one column he discloses, the other column he has.
FR, tal to FR He has decided for himself that the vigilance cases do not apply to me.
Right, right.
No court has decided it. He decides for himself. ଆଉ FIR ସେ disclose କରୁଛନ୍ତି ଯେ ଆଜ୍ଞା ଏଗୁରା ମତେ ଏଇ grounds ରେ ହେଇଛି ଆଜ୍ଞା FIR ରେ ଲେଖିଛନ୍ତି
program 5 ରେ
ହଁ
ଏଇଠି serial 8 exhibit 43
ଆଜ୍ଞା ଆପଣ sir ଦେଖିବେ
exhibit 43 page
exhibit ଗୋଟେ affidavit ଦେଖନ୍ତୁ exhibit 48 page 5 43
ଯୋଉଟା କହୁଛନ୍ତି ବାହାର କର 45 ନା 48 କଣ
43
43 ଟା ବାହାର exhibit 43
ଆଜ୍ଞା
ଏଇଟା ପରା ତଳେ ଏଟା 42 ତା ଆଉ 42 43 କହୁଛନ୍ତି ହଁ ରାଇଟ୍
affidavit in form
yes 43 ହଁ affidavit
exhibit 43
କୋଉ column ଟା
sir page 5 column C
column C yes
sections of concerned act codes involved give numbers of the section that is
PC act indicate କରିଛନ୍ତି
ଆଜ୍ଞା ସେଠି ସବୁ ଜାଗାରେ indicate କରିଛନ୍ତି PC act
ନାଇଁ ସବୁ ଜାଗାରେ ନୁହେଁ ଯେ କେତେଟା
ଯେତେଟା କେସ୍ ଅଛି
ରୁହନ୍ତୁ କେତେଟା କେସ୍ let us see
ଆଜ୍ଞା ଦେଖନ୍ତୁ
one that is serial number 3 is a PC act case then number 7 ଦୁଇ then 8 ଅଛି ହଁ 8 3
9
4 5
10
6 yes 6 and 13 ସାତଟା case let us say 7 cases under PC Act in which charge sheet has been also submitted
yes sir.
and
he himself declares it
no ସବୁଥରେ charge sheet ହେଇନି
ସବୁଥରେ charge sheet
ହେଇନି
ସବୁଥରେ charge sheet
acha okay but
FIR has been registered
okay so ତା ବିଷୟରେ କିଛି ଲେଖିଲେନି କଲମ
brief description of offense ଆଜ୍ଞା ଦେଖନ୍ତୁ
next page
next day 5D brief description of offense vigilance case କୋଟା ବି ଲେଖିଲେନି if your lordship remembers
exhibit B by 1
এটা actually heading ଆସିଥାନ୍ତା criminal misconduct ସେଇ PC act ଏଇଟା PC act ଦେଖି 13 ଟା ଯେକୌଣସି ଗୋଟେ ଦିଅ
exhibit B1 exhibit
yes criminal misconduct by a public servant that is the ମାନେ heading ତାର ଇଏଟା
ଆଜ୍ଞା
ତାର ଯୋଉ clauses ଅଛି ତେଣୁ ଏଠି what you mean to say that at least he should have mentioned that 7 cases of criminal misconduct जो gist ଟା ଦଉଛନ୍ତି ଯୋଉଟା
gist ଆଜ୍ଞା brief description of offense the rationality behind this is these are my lords all laws formed under article 324 of the constitution the rationality is ଆପଣ ଯଦି ଲେଖିଦେବେ section 394 ରେ FIR register ହେଲା तो कॉमन मैन जानी पारिबनी व्हाट इज 395 डकैती कहले से जानिबो डकैती रे से इन्वॉल्व लोकटा द एंटायर कांसेप्ट इज गिविंग कंप्लीट इंफॉर्मेशन टू द वोटर्स कि 376 लिखि देला 376 से बुझी पारिबनी रेप रे इन्वॉल्व थला तो that creates the impression that gives the information and my lords PC act has been very strongly my lords if your lordship remembers Krishnamurti's judgment they say that is a heinous crime a category of offense which includes offenses under PC act in fact PC act first deichanti someone getting elected to a public office is involved in cases of under the vigilance department, my lords, creates a very strong impression upon the voters. So he has falsely, my lords, he has not declared this in his brief description of offences.
All these, Mr. Agrawal, all these 7 cases were at the stage of investigation.
No, my lord.
What are a conviction?
PC Act case.
One case रे charge frame at the date of filing.
Conviction टा ପରେ ହେଲା ନା କଣ?
Conviction charge frame charge frame because here is a requirement. If charge has been framed, that has to be also disclosed.
अच्छा, charge ଟା ତାଙ୍କ ନାଁରେ କଣ frame ହେଇଥିଲା?
PC Act ନଥିଲା charge.
So that particular case is different, but other cases where the PC
FIR
Act
has been registered.
I mean to say that charge against a non-public servant, charge can be framed under section 13(1), let us say 13(1)(d), 13(2) read with 31, read with 120(b) of the Indian.
Read with 120. ସବୁଥିରେ 120B ଅଛି.
Charge can be framed like that.
Yes,
so,
that is, my lords, also the judgment of the apex court.
ଏଇ ଯୋଉ ନଲ୍ଲାମଲଙ୍କର ପି ନଲ୍ଲାମଲଙ୍କର କେସ୍ ରେ ମଧ୍ୟ
Lordship, sir.
that
Citation ଟା କେତେ
ସାଇଟ୍ କହୁଛି, ଏଇଟା ସେ ଜୟଲଳିତାଙ୍କ କେସ୍ ରେ ସାଇଟ୍ ହେଇଛି, wherein it is held that if such conspiracy or abatement of any of the offences punishable under PC Act can be tried by the special judge, it is inconceivable that the abater or the conspirator can be delinked from the delinquent public servant for the purpose of trial of the offense. If a non-public servant is also a member of criminal conspiracy for a public servant to commit the offense under the PC Act, or if such non-public servant has abated any of the offense which the public servant commits, such non-public servant is also liable to be tried along with such public servant before a court of special judge having jurisdiction of the matter. এই যে criminal detail ଇଏ କରାଯାଇଛି ସେଟା.
Sir, এটা citation
ଏଇଟା ହଉଛି ପି ନଲ୍ଲାମଲ ପାର୍ଟି ନାଁଟା ଲେଖି ଦିଅନ୍ତୁ.
P. Nallammal.
ସେଥିରେ ମଧ୍ୟ ତାଙ୍କର ସେ that is P. Nallammal versus state represented by Inspector of Police A 1999 6 SCC 559 and Justice K.T. Thomas and M.B. Saha. This is the sole main point which is was raised in that case, and it was decided that some of the appellants were the Keith and Keen of those public servants were charge seated, and they challenged that we are not the public servant, how we'll face trial under this PC Act ready section so on. So that was that abatement section was discussed. Then section 10 and 12 of the PC Act, which was also discussed, and it was held that they are liable and ultimately. So please verify this. This is subsequently also dealt with in some
Yes, my
other
lords.
decision. So that is why they nowadays also you will find that charge sheet are being filed with 120B of the
120. In this case, my lords, in the case where he was convicted also, my lords, cognizance has been taken.
But what has been pointed out by them
Yes,
that
my lord.
one of the case in which charge was framed and he was ultimately found guilty. By that time, there was no charge for that PC Act in that case.
My lords, cognizance was taken under
No,
the PC Act.
charge has superseded that cognizance order.
Superseded.
Cognizance was taken, no doubt, under that PC Act, but when charge was framed, that particular charge was left out. So for that particular, he need not.
One
but-
case maybe we will find out if it is there, my lords. One case, but once he has declared, my lords, that this case is pending under under the PC Act, he should be also saying that so many cases are pending.
Have you what Mr. Mishra is pointing out? Have you taken any pleading to that effect in your? ଯେ
my lords, we
ଆପଣଙ୍କର
have
ତାଙ୍କ ନାଁରେ ଆରେ ଆପଣ ନେବେନି ପ୍ଲିଡିଂ ତାଙ୍କ ନାଁରେ ସାତଟା ପିସି ଆକ୍ଟ ର କେସ୍ ଥିଲା ସେଇଟାକୁ ଏ କଲମ ରେ ଦେଖେଇଛନ୍ତି ସେଥିରେ
ହଁ ଆମେ ଲେଖିଛୁ ଆଜ୍ଞା।
ମନା କରୁଛନ୍ତି ମିଷ୍ଟର କହିଲେ
ନାଇଁ
ମତେ କହିଲେ ଯେ ସେ ଆପଣ ଦି ସବମିଶନ ୱାଜ ଦ୍ୟାଟ ୟୁ ହାଭ ନଟ୍ ଟେକେନ୍ ଏନି
ନାଇଁ ଏଠି ଆଜ୍ଞା
page 12 your lordship
page 12 your lordship
ଏଇ ଆଣ ବାହାର କର ସେ ଯୋଉ ଇଲେକ୍ସନ ପିଟିସନ କୋଉ ପାରାଗ୍ରାଫ ଟା ସେଇଟା
page 12
page 12 ସେ 7C ରେ କଣ୍ଟିନ୍ୟୁ କରୁଛି।
page 12 ଆଜ୍ଞା ଉପରୁ 13 line from top.
Top.
The respondent in column 5-2C, serial number 3, 7 to 10 and 13 has declared about the cases pending against him under section 13(2) read with section 13(1)D of PC Act, but has not declared about the same in column 5-2D of the affidavit. Thus, the respondent has made a false declaration. We have taken this plea.
And his case is that since he was not a public servant, he has not mentioned it in the second column, though he has mentioned it.
If this was the case, he should not have mentioned in column 5-2C also.
And that apart,
he has mentioned there that cases under PC Act is pending against me.
No, that column relates to that say
Exhibit 43
that column relates to registration of the କୋଉ case ରେ FIR registered ହେଇଛି ତେଣୁ ସେଠି ସେଟା କଲା ନାଇଁ ତାପରେ just a minute ସେ ଯୋଉଟା ଆପଣ ଦେଖଉଛନ୍ତି ନା C ଟା ଦେଖଉଛି କୋଉ section ରେ ଆପଣଙ୍କର ସେଇ ଯୋଉ case ଟା registered ହେଇଛି ସେଠି obviously ସେ ଛାଡି ପାରିବେନି ସେଠି ଲେଖିବାକୁ
then the D ରେ ହଉଛି brief description of offenses ସେଇ offenses ର description ଦେବେ ଆଜ୍ଞା D ଟା
ସେଇ offenses ଯୋଗୁରା ସେ reflect କଲେ column 1 ରେ ତାର description ଦେବେ। He has to describe thereafter, my lords, no court. I understand some court has quashed 13(1)D and against him. That's a separate issue. No one has quashed anything, my lords. Can he be a judge of his own cause and say that because I'm not a public servant, this will not apply to me?
FIR is exhibit. And if your lordship looks to the FIR below, lordship kindly see one FIR, exhibit 23.
Just 1 minute. My lords, what? This column 5D, my lords, explains, as I was saying, 395 ଲେଖିଦେଲେ ଲୋକ ବୁଝି ପାରିବେନି ରାସ୍ତାରେ। So, ଡକାଇତି ମୁଁ ଲେଖିବି। तो 5C ଟା elaborates, मतलब 5C ରେ ଯାହା ଦିଆ ହେଲା section, 5D ରେ brief description of offense ଦବ। You give the offenses under 5C. 13(1)D ମତେ ଏଇ 6ଟା କେସ୍ ରେ applicable, 6ଟା ନା 7ଟା cases ରେ applicable. Then you hold yourself ଯେ ଏଗୁରା ମତେ applicable ନୁହେଁ ବୋଲି ମୁଁ brief description of offense ରେ ମୁଁ ପୁରା ଉଡେଇ ଦେଲି। I do not reflect it in the brief description of offense. This is what has to be reflected as per 5C. It may not be applicable. If someone is implicated in a murder case, later on he may be found to be exonerated from that murder case. It may not be applicable to him, but he cannot decide by himself that this case is not applicable to me. Especially when the law is otherwise. And ସବୁଥିରେ 120B ବି ଲାଗିଛି.
ନାଇଁ ସେ obviously ଲାଗିବ sir, non public servant ଆସିଗଲା ମାନେ
120B ଲାଗିଛି. 120B,
That's also
120B they have
not
disclosed.
correctly.
Not correctly, that I will come later on, but 120B गुरा disclose करचंती. And my lords, the import and effect of clause D is
ସେଟା ହଉଛି କେତେ number exhibit କହୁଛନ୍ତି
43,
43.
ହଁ।
The affidavit.
page 5, column C.
ଅନ୍ୟ ଗୁଡାକ ତାର ପୁରା exact copy ହେଇଥିବ
Exact copies of
Same, seta Xerox copy, eta original.
এটা original.
44, 45, 46 is the Xerox copy
Hmm.
of exhibit 43.
ଆଚ୍ଛା କ୍ରିମିନାଲ କନସ୍ପିରେସି ବିଷୟରେ ଲେଖିଛନ୍ତି କୋଉଠି ସେ ଯୋଉ କଲମ ନମ୍ବର ଡି ରେ ଡି କଥା କହୁଛି
120B.
ଲେଖିଛନ୍ତି ଯେ 5 charges ଲେଖିଛନ୍ତି
5 charges.
whereas is it 5 charges or 7 charges ମାନେ 7ଟା କାରଣ ଚାର୍ଜ ତ ଗୋଟେ ଫ୍ରେମ ହେଇଥିଲା
ଆଜ୍ଞା
ଯେତିକ ପିସି ଆକ୍ଟ କେସ୍ ରେ obviously 120B ଥିବ ବୋଧେ
52C ରେ ଆଜ୍ଞା ସେ ଲେଖିଲେ serial number 3. I have also pleaded in page 12. Serial number 3, 7 to 10 and 13. 6 cases under section 120B.
ନାଇଁ ନାଇଁ କିନ୍ତୁ ପ୍ରକୃତରେ 7ଟା କେସ୍ ପରେ ଆମେ ଅବିକା ଗଣିଲୁ ଯେ 3 ନମ୍ବରଟା ଦେନ୍ 3 7 କୁ ଆସନ୍ତୁ
7,
ଦେନ୍ 8
8, 9,
7 8 9
10, 10,
10
10 ପରେ 13,
ଆଚ୍ଛା 6 cases ହେଲା not 7 actually
13.
ହଁ 6 cases ହେଲା 6 case ରେ ପିସି ଆକ୍ଟ ଲାଗିଛି with 120B ମଧ୍ୟ ସବୁ case ରେ ଅଛି
ଆଜ୍ଞା
which he has shown only 5 that is
Sir, ରୁହନ୍ତୁ ଟିକେ ଆପଣ ରିପ୍ଲାଏ ଦେବେ ଯେତେବେଳେ କହିବେ
brief description offense
their stand is ସେ କଣ ନା 5C ରେ ଯେମିତି ଏଠି ଲେଖିଲେ ଯେତେ କାଉଣ୍ଟ କଲେ 6ଟା ହଉଛି ଆମେ ଯେମିତି କାଉଣ୍ଟ କଲୁ ପିସି ଆକ୍ଟ 6ଟା ଏଠି ଯୋଉ ଲେଖିଛନ୍ତି ଏଠି କୋଉଠି ଲେଖିଛନ୍ତି ସେଠି ଯଦି 6ଟା ଅଛି ଏଠି ଲେଖିଲେ 5ଟା କି 3ଟା ଏମିତି ଲେଖିଛନ୍ତି ଚାର୍ଜେସ୍ ଲେଖିବା ଦରକାର ନି କେତେଟାର ଅଛି true it is not required but once he is declaring that 120B ରେ ମୋ ନାଁରେ 2ଟା କେସ୍ ଅଛି but actually ହଉଛି 6ଟା he must give the correct information. He should not have given, that's a different thing, it is not required. But once he discloses that 6 cases under 120B is pending, but in column D he declares 3 cases under 120B. Their stand it is not required. It is not required, but once he declares in C that 6 cases are pending, he must declare in D also 6 cases. He should not have written 3 cases. And if your lordship looks to the newspaper, my lord, they have exhibited exhibit B by 1. If it was after nomination, scrutiny, everything was over. They published in the newspaper, my lord. As per direction of Constitution Bench of the Supreme Court, my lord. Your lordship kindly see exhibit B by 1.
ଏଇ ଯୋଉଟା ଆପଣ କହୁଛନ୍ତି again I am asking both of you ଏ ଯୋଉ brief description of offense ଅଛି ସେଇଟା କୋଉଠି elaborate କରାଯାଇଛି ଯେ କେତେଟା କେସ୍
ଆଜ୍ଞା
ଦରକାର ନାହିଁ
ଆପଣ ସିକ୍ୱେନ୍ସ ଟା ଦେଖି ଦିଅନ୍ତୁ ସାର୍ ଏଣ୍ଟାର ଏ ର ସିକ୍ୱେନ୍ସ ଟା ଦେଖନ୍ତୁ ଫର୍ଷ୍ଟ ଏଫଆଇଆର ନମ୍ବର ଟା ଦେବେ ଏ ରେ ପେଜ 4
ସିକ୍ୱେନ୍ସ ବି ଭୁଲ ହେଇଛି ସେ ମାନୁଛନ୍ତି ଯେ
ନାଇଁ ମୁଁ ସିକ୍ୱେନ୍ସ ନେ ମାନେ ହାଉ ଦ ଇନଫର୍ମେସନ ୱିଲ୍ ବି ଡିସକ୍ଲୋଜ୍ଡ ଏ ଫର୍ଷ୍ଟ ହେଲା ଏଫଆଇଆର ନମ୍ବର ଟା ଦେବେ एफआईआर नंबर with name and address of police station concerned. ठीक है सर. Then the case number with name of the court.
तमाने जीआर केस टीआर केस जाओ
TR केस जहा केस हला आमे दबु एग्जैक्ट कोड दबु सबु दबु तापरे सर आमे दबु sections of concerned acts codes involved giving number of the section of IPC etc.
तमाने सेही केसटा जदी इन्वेस्टिगेशन स्टेज रे थिबो ताले एफआईआर रे जो ऑफेंस हेची देबे
आज्ञा
जदी चार्ज शीट हेची चार्ज शीट जो ऑफेंस
पर दिया
यस
एमती अनुए जे चार्जेस फ्रेम हेले ही दबो नाही
नहीं
everything has to be disclosed तापरे to make people understand को section brief description of offense जेमती मु कहली सर का नारे एफआईआर हेला 395 रे तो से लोक बुझी परिबे नहीं सेही पे लेखा हबो डकैती एटी एई केसटा 3 रे हेला डकैती so people will understand he is involved in a case of dacoity.
But it is not necessary what they say that it is not necessary तीनटा डकैती केस
No, it is not
ये
necessary.
जोटा जेइछंदी एडिशनल इंफॉर्मेशन माने एडिशनली से स्टेट करछंदी
Additionally
से कहजनी
stated,
सेटा
it is not required.
हाँ।
Additionally
No,
stated,
quota
but
is not required.
ये जो 2 चार्जेस 3 चार्जेस एम जो लिखिना दी कॉलम नंबर
3
डी
charges एटा जोटा लेखुचंती
हाँ
जेतेबेले एथि एफआईआर टा देले तार करस्पोंडिंग से माने लेखिबे
से खाली देखिए क्रिमिनल कॉन्स्पिरेसी इट इज नॉट
क्रिमिनल कॉन्स्पिरेसी
5 चार्जेस ऑफ
हां सेटा से
से देइचंदी से कहउचंदी जरो काउंटिंग रे भूल हेकिनी 6 जगह रे 5 कर देइचंदी बट ही हैज नॉट सप्रेस्ड इट फ्रॉम द वोटर्स दैट मोनार गोटे क्रिमिनल कॉन्स्पिरेसी रो केस अछि खाली सेती लेखिवा अपेक्षा मु जदी लेखुची मो नारे 5टा केस अछि तले रादर माने मु लोकों को सामना को आणुची जे मो नारे 5टा केस अछि बेली खाली क्रिमिनल कॉन्स्पिरेसी लेख देइथिले वे तो लोक बुझी न थांदे जे हां क्रिमिनल कॉन्स्पिरेसी गोटे केस वे थिबो किंतु मु लेखुची 5टा केस मे बी दैट काउंटिंग इज रॉन्ग और व्हाटएवर इट मे बी सो तांकर सबमिशन होची से
आया जदी गोटे जगह रे भूल थिबो आई अंडरस्टैंड एंटायर थिंग इज रॉन्ग
एंटायर थिंग आ कोन भूल
आया आपण कंपैरिजन टा देखि
ओ आ ई जो हां से 323 341 ए उडा
सब जगह रे भूल रही छै
से काउंटिंग रे भूल ना आ कोन छाडी चंदी
ऑफिस छाडी चंदी ना
जेंदी पीसी एक्ट ता छाडी दी चंदी
पीसी एक्ट ता पूरा छाडी देले
हां से छाडंतु सेमती आउ कि छाडना दी तो
सेठी एफआईआर रे सेक्शंस आर मेंशन्ड दे हैव लेफ्ट आउट दोस सेक्शंस
कोन कोन बुझी पाइली
कुछ
Exhibit 27, the FIR was registered under section 417. Here 417 has been left out, not disclosed here. 417 बदले लिखा ला 147.
just a minute को
Column 52 A रो 6 सर देखो
52
A6
C
A6 A रो 6 page 4 रे
A रो 6 टा
FIR number 136 2012 dated so and so Balyanta police station Cuttack Odisha. The correspond that FIR, if your lordship looks to that FIR exhibit 27. That FIR has been registered under section 417, 341, 323, 294, 506, 379, 120B, 34. But in the affidavit, in column 52C6, 6 ta sir, commission of offense under section 143,
147.
Sorry, 147, 341, 323, 294, 353, 427, 149.
Okay.
Please.
that order sheet day to day order sheet text को जो exhibit है उसे कहूँ सेठी कोड convenience ने जो 341 294 506 120 and 34
Exhibit, please.
Please see day to day order sheet page 4
कितना देर में
से अधिका देखैछन এইটা কোন সেই গোটা কা সেই অফেন্স সেই তো এটা
Exhibit 27
ଆପଣ সিরিয়াল নম্বর ঠিক মেনশন করনাନ୍ତି পରା ସେ
exhibit ଦେଖଉଛନ୍ତି exhibit 27 ମୁଁ ଭଲ ମୁଁ ସେଇ ପାଇଁ କହୁଛି
କଂଗ୍ରିଜେନ୍ସ କୋ ସେକ୍ସନ ରେ ଦେବେ नो ସେଇଟା କୋଉଠି ମେନଶନ କରିଛନ୍ତି ସି ରେ ସି ର କୋ
मेंशन करଛନ୍ତି 6 serial 6 से पेपर टिके रुहंतु मु कहूची नो
ସେ 12 କୁଆଡେ ଗଲା ଏଇଟା ପୁରା 6 ନମ୍ବର ରେ ଇଏ କରୁଛନ୍ତି ଓ ତାର କରେସ୍ପଣ୍ଡିଂ ଆଚ୍ଛା ଓ ସେ ଇଏ ଉପର ଦିଟା ହଉଛି ଏ ବି ରେ ଆପଣ ସିରିଏଲ ନମ୍ବର 6 ରେ ଦେଖେଇଛନ୍ତି ସେ କେସ୍ ଟାକୁ ଏଫଆଇଆର ର କରେସ୍ପଣ୍ଡିଂ ଜିଆର କେସ୍ ତାର ସେକ୍ସନ୍ସ ଟାକୁ ରିଫ୍ଲେକ୍ଟ କରିଛନ୍ତି କୋଉଥିରେ 12 ନମ୍ବର ରେ ଆପଣ ପୁରା ଇଟ୍ ଇଜ ରିକ୍ୱାର୍ଡ ଦ୍ୟାଟ ଆପଣ ସେ ସିରିଆଲିଟି ଟାକୁ ବି ମେଣ୍ଟେନ କରିବେ ଯଦି 6 ନମ୍ବରରେ ଏଫଆଇଆର ହବ 6 ନମ୍ବରରେ ଜିଆର କେସ୍ ଟା ତାର ମେନସନ କରିବେ 6 ନମ୍ବରରେ ତାର ଅଫେନ୍ସ ଟା ମେନସନ କରିବେ 6 ନମ୍ବରରେ ତାର ବ୍ରିଫ ଡେସ୍କ୍ରିପସନ ଦେବେ ଏଇଟା that is the thing na
Yes.
ମୁଁ ଆଜ୍ଞା ଟିକେ ଏଇଟାକୁ କ୍ଲିୟର କରିଦେବି ପ୍ଲେସ୍ କରିଦେବି ମୁଁ ପୁରା କହିଲି have not disclosed correct information and to above it is their stand no I have correctly disclosed so we brought certified copies of FIR and order sheet exhibited and we have confronted him he admitted it's a typographical error
according to you such averment is sufficient
Averment is sufficient.
yes I have said jota detail jemti are 5C re I have said stated your lordship kindly see
ତାହେଲେ ଏଗୁଡାକ ଏତେ ଜିନିଷ ବି ଦବାର ନଥିଲା 7 ଯଦି ସେତିକି ସଫିସିଏଣ୍ଟ ଏତେ ଗୁଡା କାହିଁ ଦେଲେ ତାହେଲେ
ସେଇଟା କହିଛି ଏଟା ସ୍ପେସିଫିକ ବି କୁହା ହେଇଛି your lordship kindly see my pleading page 10 paragraph 7C ର 8 line
paragraph
7C page 10 ର 8 line top right hand side in column in column 52A6 the respondent has mentioned FIR number 136 2012 dated so and so in Balyanta police station Cuttack Odisha whereas there is no Balyanta police station in the district of Cuttack similarly the respondent mentioned then your lordship may skip over the next page ଟିକେ ରୁହ ଭାଇ ମୁଁ କହୁଛି ଆଜ୍ଞା ଇଏ ଯଦି ଏମିତି କହିବେ ଆଜ୍ଞା ତମେ ରିପ୍ଲାଏ ଦବନି this is not the way my lord
just a minute yes next page
my lord page 11
କୁ ଆସ yes
page 10 ରେ ଅଛି ଆଜ୍ଞା ତଳୁ ଆରମ୍ଭ ହେଇଛି similar last two line similarly the declaration made in column 52B serial number 9 by the respondent about GR case number 680 of 2012 in the court of SDJM Bhubaneswar is false and misleading declaration. There is no GR case number 680 of 2012 pending against the respondent in the court of SDJM Bhubaneswar. Rather, a GR case number so and so is pending against the respondent in the court of JMFC of Bhubaneswar. Further, the FIR numbers given in column 2A and corresponding case numbers and the name of court declared in column 52B and sections of concerned acts codes involved are false and misleading declaration.
As held by the apex court in all the decisions, this is within his special knowledge. Your lordships is to see, I'll bring it to the notice of your lordship, indicating the discrepancies. Your lordship, because this is within his special knowledge. Mu to jani paribi nahi na. Taro declaration na whatever we come to know, we are giving the information to your lordships. After that, because at the time of even filing the election petition, all the information will not be with us because 45 days before I have to file the election petition. So he has to give correct information in the affidavit. Then when he again files a written statement before your lordship, He has to give the correct information. So on that basis, your lordships will have to adjudicate the entire case. Krishnamurti, I guess, he has the special knowledge. We don't have special knowledge of the criminal cases against him. Jadi my client nare dita criminal case will he be able to find out? Mate declare kariya kotha setru jaha bhul baharibo seta.
If your lordship looks to his deposition, he himself, your lordship, kindly see page 34.
RW1. Mokim. Who page kondu?
Page 34, para 62.
62 page. 62 पहले परा
Para 62, page 34. Cross-examination below.
Yes.
Exhibit 27 is the certified copy of the order sheet of GR case number so-and-so pending in the court of JMFCO Bhubaneswar, along with the certified copy of the FIR in Balyanta PS case number so-and-so. Balyanta police station comes under Bhubaneswar urban police station. It is not a fact that I have made a false declaration by mentioning column 52A6 that FIR number so-and-so Balyanta police station comes under Cuttack. It was a mistake on my part to mention Cuttack in place of Bhubaneswar. However, then he explains that as the Bhubaneswar and Cuttack is under one commissioner, so I have seen. Then your lordship may skip over last line. Exhibit 27 indicates that the said case is pending in the court of JMFCO Bhubaneswar. It is a typographical error on my part to mention SDJM Bhubaneswar in place of JMFCO. Then again, your lordship, your lordship may skip over. He himself volunteers. Your lordship will get it. Say tale. Fourth line from top. Say jo volunteers or chari line. It is a fact that even though Balyanta PS case number 136 dated 24/9/2012, which corresponds to GR case number so-and-so pending in the court of JMFCO Bhubaneswar, was registered under section 417, 341, 323, 294, 506, 379, 120B, 34 of Indian Penal Code. But in my affidavit mark exhibit so-and-so, I have not mentioned these offences in column 52C, where it was required to mention sections concerned acts code involved given number of sections so-and-so. The witness again says that the offences are mentioned under column 52C6. The witness again says he cannot say in which column 52C the same has been mentioned. It is a fact that even though one of the offense under which Balyanta PS case number so-and-so was registered is section 417 of the IPC of my affidavit mark exhibit so-and-so, where I have mentioned the offences of different cases instituted against me, I have not indicated that a case under section 417 of the IPC is pending against me. The witness volunteers that it may be a typographical error to leave such offense in the said column. It is a fact that in none of the offences indicated in column 52C, I have mentioned that a case under section 506, 379 of the IPC along with other offences are pending against me as Balyanta PS case number.
Somewhere he has stated about typographical error.
Yes.
Somewhere clerical error. Somewhere said I cannot say my advocate can.
My advocate can tinita stand against agaro. Gote hochi typographical error. Other is clerical error. Third is my advocates can say. It's not that we have not pleaded. Material facts has been pleaded. These documents were exhibited, my lord, to show, and they stand in the written statement and examination chief. No, I have correctly disclosed. In the written statement or in some cases he has said in the examination chief typography, but in other cases he said it is correctly disclosed.
So, in sum and substance, so far as these criminal offences are concerned, Mr. Kanungo, your submission is that not only the FIR numbers and police station information, GR case number or TR case number or ST case number, offenses and the description of offenses, those are to be serially mentioned and correct
Correct.
with correct information. Nothing to be suppressed.
Nothing
No
to be
wrong
suppressed.
information is to be given.
Yes,
If it is given, then that is withholding of information
from the
from the
public.
voters,
From
and that may be a ground also to. Okay.
My lords,
So,
that is-
we'll verify. You can give those things in.
yes,
have
but
note, in
we
note
have
I have
given the
given,
note,
I'll
we
give
have-
detail. A column exhibit 43 shows this.
Hmm.
He has mentioned this in our examination in chief. We have stated this on cross examination. We have stated this. He in chief says this. Cross examination is this. That I'll give in detail, my lord.
So, so far as criminal offences is concerned, any further submission?
He has suppressed this vigilance case kichi lekhile nahi. He stand that he takes, which has been rightly held by your lordship, that vigilance can be attracted against a private person under if 120p is added. So he cannot be a judge of his own cause and say no, vigilance cases are not applicable to me. And vigilance cases, your lordship, that judgment Krishnamurti apana padhibe, is one of the worst form of cases that a person who is contesting for public office can have, because he is stealing from the public sector or the public my lords institutions. So he says that has to be mandatorily disclosed, which he has not done in the brief description of offences. And the stand that has been taken, because we are not public servants, whether that stand is acceptable or not, that your lordships will see. So my lords, that is a clear suppression of fact of a very heinous offence.
Important.
Then
ଖାଲି ଗୋଟିଏ ଆଜ୍ଞା ଗୋଟେ
ଆଉ ଗୋଟେ
exhibit 43 ର column F. He has declared charge କୋଉ ଦିନ frame ହେଲା, he has to declare. That date is also he has declared wrong.
Who column?
F, page 7, F.
F.
If answer against the above is yes, yes माने अच्छा charge ହେଇଛି କି ନାହିଁ? अच्छा से ତା ସବୁଗୁଡା ତ no ଦେଖେଇଛନ୍ତି, ଗୋଟିଏ ଦେଖେଇଛନ୍ତି yes.
ଗୋଟେରେ ଆଜ୍ଞା, that is correct.
Data. Pleading
Pleading it is his special knowledge he has to show before your lordship whether it is correct or not.
1 of 2009 ରେ charge frame ହେଇଛି 29/8/2013 in the court of special judge vigilance Bhubaneswar. कौन भूल है लादिरे?
एथरे आज्ञा से चार्ज फ्रेम ହେଇଛି
10/4/2015 ରେ
10/4/2015 ହଁ ଆଗରୁ ଦେଖି ତୁମେ ମନ ଇଚ୍ଛା ଦେଖିବ।
अच्छा
ଗୋଟେ ଲୋକ ଯାଇ ଅର୍ଡର ସିଟ୍ ଖୋଜିବ
ପ୍ଲିଡିଂ କଣ ଦରକାର? within your special knowledge.
just a minute 29/8/2013 ରେ ତାଙ୍କ ନାଁରେ ଏମିତି ଚାର୍ଜ ଫ୍ରେମ୍ ହେଇନି, but to that effect
document that judgment has been, we have marked that judgment जोटा conviction ହେଇଛି ତା ଦେହରେ ଉପରେ ସବୁ ଲେଖା ହେଇଛି
କୋଉ ଦିନ charge frame
entire thing has been mentioned in that judgment.
that is the format
Yes.
charge ତା ଦେହରେ mention ହେଇଛି 2015 ରେ charge
10/4/2015
because he has special knowledge of these facts. Whatever information he is giving to the public, he has to give correct information.
But what Mr. Mishra says, is it correct that you have not mentioned in the pleading
But
that
we did not know that the charge has been wrongly framed. Once we got the judgment, only then we came to know. It's within his special knowledge.
no ଆପଣ ପ୍ଲିଡିଂ ରେ ସିନା ନଥିଲା, ଆପଣ ଏଇ ଯୋଉ ଡକ୍ୟୁମେଣ୍ଟ ଗୁଡାକ କଲେକ୍ଟ କଲା ପରେ ଯେତେବେଳେ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଆଫିଡେଭିଟ ଫାଇଲ କଲେ, ସେଗୁଡା ସେତେବେଳେ ତ ଡକ୍ୟୁମେଣ୍ଟ ଆପଣଙ୍କ ହାତକୁ ପଳେଇ ଆସିଥିଲା ନା।
ଆପଣ ଇଲେକ୍ସନ କେସ୍ କରି କହୁଛନ୍ତି amendment cannot be allowed.
କହିବା କଥା ଯେ ଆପଣ ଯେତେବେଳେ ଠିକ ଅଛି ଆପଣଙ୍କ ପାଖରେ ଇଲେକ୍ସନ ପିଟିସନ ଫାଇଲ କଲା ବେଳେ ଇଏଟା ନଥିଲା, but when you subsequently when you got these documents and came to know that ସେଟା at least mention କରିଥାନ୍ତେ, ତାପରେ ସେ ଯଦି ପ୍ରଶ୍ନ ପଚରା ଯାଇଥାନ୍ତା ଯେ ପ୍ଲିଡିଂ ରେ ଏଠି ନାହିଁ, ଆପଣ ହୁଏତ କହିପାରିଥାନ୍ତେ ଯେ ମୁଁ ଆମେ ପରେ
examination in chief ରେ we have stated.
କୋଉଥିରେ
examination in chief ରେ
ଉଲ୍ଲେଖ କରିଛନ୍ତି?
ଆଜ୍ଞା
ଆଚ୍ଛା ଏଇ ଦେଖିଲେ
Paragraph 18.
page 13, exhibit 36,
just page କେତେ କହୁଛନ୍ତି?
page 13,
13
para 18,
evidence affidavit ଟା ତାର ଯୋଉ evidence ଟା ଯୋଉ election petitioner ର ଯୋଉ
exhibit 36.
36
Lordship got it, para 18.
just ଏଠି ପୁରା ବାହାର କରିଥିଲେ ଏଗୁଡାକ ସବୁ ଡିପୋଜିସନ ଏ ଡିପୋଜିସନ ପ୍ରଥମରେ ଥିବ ଏଭିଡେନ୍ସ ଆଫିଡେଭିଟ୍ ହଁ କେତେ ପାରାଗ୍ରାଫ କୁହନ୍ତୁ
18.
18 ବାହାର କର ହଁ
That in column 52F, the respondent has declared that in TR number 1 of 2009, charge was framed against him on 29/8/2013 in the Court of Special Judge Vigilance Bhubaneswar. The above declaration that the charge framed on 29/8/2013 is false. In the said case, charge has been framed on 10/4/2015. I have filed the certified copy of order sheet so and so. So we have stated me.
And they have not cross-examined also.
ଓକେ ଆଜି ଏଇଠି ରଖିବା
ଆଜ୍ଞା।
କାଲି ଏଇଟା ସରିଗଲା ତ କ୍ରିମିନାଲ ଅଫେନ୍ସ ଗୁଡାକ
କ୍ରିମିନାଲ ଆଉ ଯଦି ଆଉ ଟିକେ ଥିବ କାଲି ଆଉ
ହଁ।
ଜଜମେଣ୍ଟ ସରିଗଲା ଆଜ୍ଞା ଆଉ ସବୁ
ଏଇ exhibit ଟା ଦେଖିବାର ଅଛି ଖାଲି।
ଏଇ ଜଜମେଣ୍ଟ ଆଉ ଏକ୍ସିବିଟ୍ କୋଟା ଦିଟା ଦେଖିବାର ଅଛି।
ତ କାଲି ସେଇ ଦିଟା ବେଳେ ତ ଟେକଅପ୍ ହବ
ଆଜ୍ଞା।
ଏଇ ଜଜମେଣ୍ଟ ଗୁଡା ରଖାଯିବ ଯୋଉ ତାକୁ ଅଲଗା କରି ରଖୁଛ ନା ତାଙ୍କର ନାଇଁ ଜଜମେଣ୍ଟ ଗୁଡା ଯୋଉ ଦଉଛନ୍ତି ତାଙ୍କ ଗୋଟେ ଫାଇଲ yes
Supplemental list item number 1. Item 3.
yes
7 years for 467 and for 25 years.
what is the operative part of the judgment
7 years for 467.
who part টা
Fif-
page number କେତେ
Page 52 mala.
50
52.
52 7 years so and so 1,04,67 so and so oh right admit call for the trial court record the deposition copy to be supplied to the state council matter to be listed after receipt of the trial court record. Yes
Item 5.
5 Mr. Tapos Kumar Acharya. এটা কোনটে?
The SCST bail minus
SCST.
302 is there. CD is required,
Okay.
notice to go.
Notice to be issued. One of the offenses is CSTR. Extra copy to be served. And ଗୋଟେ ସପ୍ତାହ ପରେ. Yes, CDCA to be obtained along with the compliance report regarding service of notice. Yes.
Item 6.
May I please?
Item 6 on SCST bail matter.
SCST bail.
SCST bail.
Fresh matter.
Fresh mail.
Yes,
Okay.
fresh.
Same order. Extra copy. CDCA and confirmation letter. Yes.
Item 7. Item 8.
criminal antecedent. Huh?
Item 8, my lord, the earlier, the petitioner was earlier before this honorable court by BLPL number 5541 of 2023, which is disposed of by my lord Justice, Honorable Justice C.R. Das, my lord. But due to wrong tagging of the case, which is tagged, my lord, as it appears from the noting, 8582, this is not related to the present petitioner, my lord. For which,
No, not necessary that it should be of the present petitioner.
no,
If
no,
I have-
only one petitioner in this case, my lord.
Huh?
Only one petitioner. FIR sole accused.
This-
এই বেলটা
just a minute. এটা হচ্ছে ମୁଁ ଯୋଉଟା tag ହେଇଛି ଆ ଦେହରେ
ସେଇଟା ଆପଣଙ୍କର dispose.
ନକ୍ତି ଦେଉଳି PS case number 70 of 2020.
376 case. I have checked also.
That's a different case.
376.
Difference case. এইটা 302 man.
Yes, case number is also different. And this case
The Learned counsel for the petitioner submits that this case has been tagged, listed before this court on the ground that the earlier bail application in BLAPL number 8582 of 2022 was disposed of by this court, by this bench on 25/11/2022. But the said case relates to a different PS case, and since the earlier bail application of the petitioner in BLAPL number 5541 of 2023 has been disposed of on 23/5/2023 by another bench, the matter may be listed before the said bench. In view of such submission, the registry shall take steps for listing the matter along with BLAPL number 5541 of 2023 before the appropriate bench. Yes, next. ଅଛି ତ ଆପଣ ଯେତେବେଳେ ହିୟରିଂ ହବ ଆପଣଙ୍କ ନାଁ ତ ଆସିଛି ଆଉ କଣ ଯେତେବେଳେ yes.
Item 9.
ର କଣ ଗୋଟେ extending time, but non-appears IS stands dismissed. Yes, next.
Item 10.
10, my lord, matter may be called 2 weeks after, my lord. I will furnish a property surety. Earlier, I have given the property surety, that was a joint property.
Mr. Mahanti, Land Council, appearing for the petitioner, seeks for an adjournment. Adjourn, give another date. Yes, next.
Item 11.
Lordship, on behalf of Mr. Chand, Lordship, praying for short adjournment.
11 more.
Item 11 is Mr. Pitambaracharya.
Yes, Lordship. Previously, we have filed collection.
Mr. Panda, कौन कहले?
No, 13.
अच्छा. You want adjournment?
Lordship.
On behalf of Mr. Pitambaracharya. Huh?
Mr. Chand, Lordship.
कौन?
On behalf of Mr. Chand, Lordship. Previously,
Manas Chand, अच्छा.
Yes.
Okay. Mention is made on behalf of Mr. Manas Chand to adjourn the matter. Adjourn. Yes, next.
The copy may be served, IA copy.
IA copy. The copy of the interim application be served on the Land Council for the state. Yes.
Item 12.
MA, Mr. Olli, what is this modification you want?
Actually, in this case, my lord, this honorable court has pleased to pass an order of granting bail. Bail was granted to this present petitioners, my lord, on 4/1/22. But so far, actually, this present out of 7% free and ladies, my lord. Another person is aged about 75 age, my lord. So they could not be able to surrender before the real court. The court belongs to JMFC Liali, my lord. JMFC, but actually, the order is, I filed this petition, my lord. I quoted with my petition JMFC Kotak, my lord. the according order has been passed by this Honorable Court. So due to defect in my petition, due to typographical mistake, my lord.
So that JMFC R Kotak would be JMFC
Nearly, my lord.
Niali.
Yes.
That is the only
That is only
modification.
GR case number 76 of 2019 would be there.
GR case number to kichi mention ही नहीं खाली नियाली PS case number.
But my application is concerned, I have mentioned my present application. Actually, GR case number which nearly GR case number which 76 by.
No, you are to show the proof of that. Mere averment would not do. ଆପଣ certified copy obtain kale FIR ର ତା ଉପରେ GR case number mention ହେଇଥିବ। ତେଣୁ ମତେ ଦେଖାନ୍ତୁ ବର୍ତ୍ତମାନ GR case ଟା ଆଗରୁ mention ହେଇନି। ଆପଣ ପ୍ରଥମେ ଯୋଉ ବେଲ୍ ଆପ୍ଲିକେସନ ଦେଇଥିଲେ ତା ଦେହରେ GR case number ଡ୍ୟାସ୍ ଦେଇକି ଛାଡି ଦେଇଛନ୍ତି। ତେଣୁ ସେଇଥିପାଇଁ ମୁଁ mention କଲିନି ଅର୍ଡରରେ। ତେଣୁ କେବଳ
so far my client's information is concerned.
ଆପଣ କ୍ଲାଏଣ୍ଟ ଇନଫର୍ମେସନ କଣ ଦେଲା ମୁଁ ଜାଣିନି। ଆପଣ ମତେ ଆଣି ଦେଖିବାକୁ ପଡିବ ଯେ ଆପଣ ବର୍ତ୍ତମାନ ଯୋଉ GR case ଟା ନମ୍ବର ଟା ମେନସନ କରିବାକୁ କହୁଛନ୍ତି that corresponds to ନିଆଳି PS case number 87 of 2019 and that can be proved only by producing the certified copy of the FIR. So you produce it, I will modify that.
No, FIR I have.
ସେ କଣ କଟକରେ ରେଜିଷ୍ଟର ହେଇଥିଲା ଜିଆର ନିଆଳି କୋର୍ଟ ହେଲା ତ ସେତିକି ଶିଫ୍ଟ ହେଲା ପରେ ଆଉ ଗୋଟେ ପୁଣି ଅର୍ଡର ଶିଫ୍ଟ ହୋଇଗଲା।
No, actually so far present GR is concerned of the nearly actually 76 by 2019 my lord.
ମତେ କଣ ଗୋଟେ ଦେଖାନ୍ତୁ ସେ ଏଇ କେସ ର GR କେସ୍ ନମ୍ବର ଟା ଏତିକି ବୋଲି। ସେ ଯୋଉ GR କେସ୍ ହଉଛି ତା ଦେହରୁ ଟ୍ରାନ୍ସଫର ହେଇଛି ଯଦି ଯାହା ଆପଣଙ୍କର ନିଆଳି କୋର୍ଟ ହେଲା ପରେ ଯେ ଯାଇଥିବ ତାହେଲେ ମେନସନ ହେଇଥିବ କିଛି ଗୋଟେ।
My actually this is the information by my client. 76 by actually 2019 present GR case number or nearly JMFC nearly by lord.
ଶୁଣନ୍ତୁ କୋର୍ଟ ନା ଅଲଗା GR କେସ୍ ଗୋଟେ ମୁଁ ମେନସନ କରିଦେବି ସେଠୁ ବେଲ୍ ଅର୍ଡର ଟା ହେଇଯାଇଛି ଆପଣ ଆଉ ଗୋଟେ କେସ୍ ରେ ଜଷ୍ଟ ଏକ୍ସାମ୍ପଲ ଦେଇକି କହୁଛି ମତେ ଖାଲି ତ ମତେ ପ୍ରମାଣ ଗୋଟେ ଦରକାର ଯେ ସେଇ କରେସ୍ପଣ୍ଡିଂ କେସ୍ ଟା ନିଆଳି PS କେସ୍ ର ଏଇ କୋର୍ଟ ରେ ପେଣ୍ଡିଂ ଅଛି ଏବଂ ତାର GR କେସ୍ ଏତିକି ମତେ ଦିଅନ୍ତୁ। ସେତିକି ଦେଇଦେଲା ଆଉ କିଛି ତ ଅସୁବିଧା ନାହିଁ ମଡିଫାଏ କରିବାକୁ ଆପଣ GR କେସ୍ ବି ମେନସନ ହେଇଯିବ।
What happens my lord actually warrant has been issued against the present petitioner. Non-bailable warrant NBW has already been issued against the present petitioner.
କଣ ଗୋଟେ ପ୍ରମାଣ ଆଣିବେ ତ
I will
bring it.
But till then they may not be arrested.
ଆରେଷ୍ଟ ପୁରା ଅର୍ଡର ଅଲରେଡି ପାସ୍ ହେଇଛି ଇନ କନେକ୍ସନ ୱିଥ ଯିଏ ଆପଣଙ୍କୁ ଆରେଷ୍ଟ କରିବ ଆପଣ ଦେଖେଇ ପାରିବେନି ମତେ ଆରେଷ୍ଟ ନ କରିବାକୁ ଅର୍ଡର ହେଇଛି ଫାଇନାଲ ଅର୍ଡର ପାସ୍ ହେଇଛି ଏଇ କେସ୍ PS କେସ୍ ସଂକ୍ରାନ୍ତରେ ଏଇ କେସ୍ ରେ ଏଇ କେସ୍ ଟା ଯୋଉ ଆସିଛି ୱାରେଣ୍ଟ ଏଇଟା ସେଇ PS କେସ୍ ର ମତେ ଆରେଷ୍ଟ ନ କରିବାକୁ ଅର୍ଡରଟା ହେଇଛି ସେଟା ଆପଣ ଦେଖେଇ ପାରିବେନି।
Since the court has already issued NBW my lord, so now they are police is.
What is the order of issuance of NBW? ଆପଣ କେତେ ଇନଫର୍ମେସନ ଲ୍ୟାକିଂ କରୁଛନ୍ତି ଆପଣ ଆଣୁଛନ୍ତି ଗୋଟେ ଟୋଟାଲ ଚେଞ୍ଜ ସିନେରିଓରେ ଆପଣ GR କେସ୍ ଦିଆଯିବ ଆଉ ଗୋଟେ କୋର୍ଟ ନା ଦିଆଯିବ ୱାରେଣ୍ଟ ହେଇଛି ତାର କୌଣସି ଡକୁମେଣ୍ଟ ଆପଣ ଦଉନାହାନ୍ତି ମୁଁ ମଡିଫାଏ କରିଦେବି 22 ର ଅର୍ଡରଟା ହାଉ ଇଜ ଇଟ୍ ପସିବୁଲ 4000 ଆପଣ ସେତେବେଳେ ଛାଡିଦେଲେ ସବୁ ବର୍ତ୍ତମାନ ସେଗୁଡାକ ଇନସର୍ଟ କରିବାକୁ ଯାଉଛନ୍ତି yes it will be done but provided that I am satisfied that this relates to that case particular case ତେଣୁ ଆଉ ଗୋଟେ GR କେସ୍ ରେ ମନେକର ଆପଣଙ୍କ ନାଁରେ ୱାରେଣ୍ଟ ହେଇଛି ମୁଁ ବର୍ତ୍ତମାନ କରିଦେବି ୱାରେଣ୍ଟ issued against in that GR case against you is stayed it may be some other case ଆଉ କୋଉ କେସ୍ ହେଇପାରେ ଆପଣଙ୍କ ନାଁରେ ତେଣୁ ତାକୁ ଗୋଟେ ଲିଙ୍କ ଦେବେ ତ ମତେ ଆଣନ୍ତୁ the land council for the petitioner seeks some time to produce the relevant documents to show that Niali PS case number 87 of 2019 corresponds to GR case number 76 of 2019 pending in the court of London JMFC Niali in which case non-bailable warrant of arrest has been issued against the petitioners all right କେବେ ରଖିବି କୁହନ୍ତୁ ଆପଣ ଆଣିକି ଦେବେ ମତେ
Next week Monday.
Put up this matter in the week commencing on 29th week commencing from 29th. Yes.
Item 13.
Please, your lordship.
Lordship, by order dated 19/5/2023, your lordship was pleased to grant bail to the petitioners. Now, while granting bail,
What is that order?
19/5/2023.
Yes.
If your lordship will look at that order,
Hmm.
in the it's not been paragraphs have not been numbered.
Hmm.
It will be in the third page of the order.
Hmm.
Let petitioners be released on bail, the paragraphs. Your lordship has imposed conditions that petitioner 1 will deposit 25% of the cheating amount, 2 was to deposit 25% of the cheating amount, besides the bail bonds. And your lordship also directed that this cash security was to be deposited in 6 equal monthly installments. Now, since there was no cash, my lords, available, your lordship modified the order on 3/11/2023. When your lordship modified the order, your lordship asked the EOW to furnish an affidavit as to the correctness of the averments of the petitioners. Now, they supplied, your lordship may look at the page 2 of that order. They supplied and they filed an affidavit where they stated, as per affidavit filed by the Additional Superintendent of Police, Economic Wing, dated 29/8, there are other properties of petitioners and 8 registered sale deed numbers have been indicated. Copies of sale deeds have been annexed to the affidavit. And then they stated in that affidavit that one of those properties is under equitable mortgage with the Bank of Baroda. So I made a submission that those 8 registered sale deeds in original will be deposited in the court below. And accordingly, your lordship also allowed it and directed that in place lieu of cash security, these sale deeds have to be deposited. The problem, my lords, is that these sale deeds, they have been sold much prior to that. So I have come up and with another IA, that is 34. If your lordship will look at page 4 of the IA, paragraph 8, my lords, that after obtaining certified copy of the order, son of petitioners tried to trace out the aforesaid sale deeds in his house to deposit before the learned court below, but in vain. Thereafter, he applied for certified copies of all the aforesaid 8 sale deeds, found that land involved in the sale deeds have already been sold, and there is no land or sale deeds available with them. And in such circumstances, there is no original sale deed available with the petitioners. Then I have explained that so far as RSD number 8814000650 is concerned, I have stated that it has been sold to one Pappu Agarwal of village Kega. The other are then paragraph B 8816000055. That has been sold to one Muhammad Salim of Bhavani Patna on 13/6/2016. 88160227.
Now that means the information which you gave to this court was wrong.
The
on that.
information which the EOW gave that there are 8 properties, that is incorrect.
Now, so if these properties cannot be, you have to deposit the cash security then.
Well, Lord, I have no cash. As I told your lordship, we could not arrange the cash.
Arrange then some other properties if otherwise that condition remains. That was only modified taking into account.
My lord, I agree.
You made a submission that property I am ready to furnish.
I agree, sir, because the EOW said that, though I said yes, I'll submit. But out of that also again, my lord.
No, while asking for modification, in that application you must have indicated that you have got some other properties. You may be permitted to give the property security in lieu of that cash security.
Lords, your lordship may see that I have not made that ever. I have said that I have not.
IA number? What is that IA number?
That is IA number 862 of 2023.
ଲେଖିଛନ୍ତି furnish property security ଲେଖିଛନ୍ତି। So, Mr. Panda, you just obtain that who can, if those properties are left out
Yes.
because it has already been sold,
Right.
if any other properties are available with you, then just collect that and give it so that it will be verified. And
in that IA 862 Millers, what I had stated is
you come to the even prayer portion, Mr. Panda,
yes,
directing the
to
petitioner
furnish
to
property
furnish.
security.
So property security
Security
ଆପଣ
the
ଦଉନାହାନ୍ତି,
other people
ମୁଁ ତ
millers
allow
I'll have to
କରିଦେଇଛି
add.
because ଯାହାହେଲେ ଗୋଟେ property security ତ
ଆଜ୍ଞା।
ଦେବେ, ତ cash security ଦେବେନି, property security ଦେବେନି, ପୁଣି
ନାଇଁ ନାଇଁ ସେଇଟା ମୁଁ କହୁନି, ମୁଁ ସେଥିଲାଗି କହୁଛି ଆମର ତ ନାହିଁ ଧରିକି ଆଉ କାହାର ଦେଖିବି।
ଯାହା ବି ହେଲେ ତାର ଗୋଟେ ଡିଟେଲ ଦେଇଦେଲେ ସେ property
Then
security
your lordship may give
authentic।
me a week's time.
ହଁ ଠିକ ଅଛି। The IN number 34 of 2024, this is an application for modification of the order dated 3/11/2023. Mr. Panda submitted that the cell deeds which the numbers of the cell deeds which were indicated in the order dated that is what is that order dated 3/11/2023. Three cell which were referred to in so and so as per the affidavit filed by Additional Superintendent of Police Economic Wing CIDCB Odisha Bhubaneswar dated 29/8/2023 have already been were sold to some other persons and he may be given some time.
And one of them doesn't belong to me.
And one of such property is also not doesn't belong to the petitioner, and therefore he may be given some time to get information about the property security which the petitioners can furnish in lieu of cash security, which was imposed on them as per the condition terms and condition of the bail order dated 19/5/2023 ହେଲା ତିନିଟା order ଦେଖିକି ତାପରେ ଏଟା ଲେଖିବେ। yes ଗୋଟେ date ଦେଇ ଦିଅନ୍ତୁ, ଗୋଟେ ସପ୍ତାହ ପରେ ଦେଇ ଦିଅନ୍ତୁ। yes
Item 14.
Item 14, I may be permitted, my lords. Earlier application, that is BLAPL 2972/2022, was disposed of on 26/7/2022 on the ground that trial has commenced, my lords. And in the meantime, my lords, the petitioner filed this present application, and lordship by the last order called for the status report as well as the deposition copies, my lords. That is at flag K, my lords.
Status report indicates that 36 witnesses have been examined, and delay of in progress of trial is due to non-appearance of the eyewitnesses. Summons have been issued and it could not be served. Some of the eyewitnesses are of West Bengal. The case is now posted to such and such date for examination of these eyewitnesses.
My lords, petition is in custody since 17 March 2021, my lords. Nearly about 3 years. If your lordship can consider interim bail for some period, my lords.
No, your bail application was rejected on merit.
Yes, my lords, that was on the ground that order must be there, my lords. On the ground, on sole ground, that trial has commenced. That was the only one line order, my lords.
What is that? What is your earlier application?
My lords, BLAPL 2972/2022, my lords.
Have you not given that a 2972 passing target? You have not filed, Mr.
I have given the reference.
ରେଫରେନ୍ସ ହେଲେ କଣ ହବ? ଅର୍ଡର ଟା ବାହାର କରିବେ ନା ଅପଲୋଡ ହେଇନି କି ଦେଖିଛନ୍ତି?
ଅପଲୋଡ ହେଇଛି ଆଜ୍ଞା, ଅପଲୋଡ ହେଇଛି।
ହେଇ ତ ବାହାର ଦେଲେନି କଣ ଗ୍ରାଉଣ୍ଡରେ ରିଜେକ୍ଟ ହେଇଥିଲା? ସେତେବେଳେ କଣ ଟ୍ରାଏଲରେ କୌଣସି ସାକ୍ଷୀ କୁ ଏଭିଡେନ୍ସ କୁ କନସିଡର କରା ହେଇକିନି ରିଜେକ୍ଟ ହେଇଥିଲା ନା ନାଇଁ ସେମିତି ରିଜେକ୍ଟ ହେଇଥିଲା?
ସେମିତି ରିଜେକ୍ସନ ହେଇଥିଲା, only because trial has commenced, ସେମିତି ମିଲର୍ସ।
ଆଉ ସେତେବେଳକୁ କେତେଟା ସାକ୍ଷୀ ହେଇଥିଲେ? ବର୍ତ୍ତମାନ ତ ହେଇଛନ୍ତି 36ଟା ସାକ୍ଷୀ। Then you must furnish the evidence copy of those witnesses that is available here.
Lordship has called for the deposition, yes.
No, that is available with me. Is it?
But
Is
it was written in the order, previous order, on
Ah.
10/11/23. Out of 18 charge sheeted witness, some witness have been examined.
No, সেটা ভুল submission ହେଇଥିଲା. In fact, the status report indicates that total charge sheet witness is 67. You must have got the charge sheet copy.
Like a CD is not there.
Oh, I see. 67 charge sheet witness ରୁ କେତେ ଗୁଡାକ ସାକ୍ଷୀଙ୍କ ନା ରିପିଟ କରିଛନ୍ତି, ବାକି 36ଟା ସାକ୍ଷୀ ସିଏ ଏକ୍ସାମିନ ହେଇଗଲାଣି ଟ୍ରାଏଲ କୋର୍ଟରେ। ଡିପୋଜିସନ ଆଟ୍ ଫ୍ଲାଗ କି କଣ ଗୋଟେ ସାକ୍ଷୀ ଦେଇଛି କଣ? ସେ ଡିପୋଜିସନ କୁହାଯାଇଥିଲା ପଠେଇବା ପାଇଁ ତ?
Yes, Miller, that was the direction, Millers.
ଅର୍ଡରଟା ବାହାର କରୁ।
Yes, there is order.
The deposition copy while sending the status report shall send the xerox copy of deposition of all the witnesses examined so far. ଏ ପଠେଇଛନ୍ତି ଦେଖିଲ ସବୁତକ? ଆଉ କୋଉ ସାକ୍ଷୀର ପଠେଇଛନ୍ତି? ହଁ 1 2 3 4 5 ପାଞ୍ଚଟା ସାକ୍ଷୀ ପଠେଇଛନ୍ତି, କିନ୍ତୁ ଆ ଦେହରେ ଲେଖୁଛନ୍ତି
36ଟା।
ଶୁଭୁନି? Decline ମାନେ cross examination declining. ତୁମେ with due regard to the so-and-so passed by the High Court in so-and-so, I am to submit here the status report pending so-and-so corresponding to city. In the file of, I am to state that so far in the case 5 witnesses have been examined from the side of the prosecution. Examination of 4 witnesses have been declined, though the charge sheet indicates, but the names of most of the witnesses have been repeated. Thus in total 36 witnesses have been. अच्छा ये 36टा witness से कौन ହେଇଛି ନା 67 witness କର ନା ଦିଆ ହେଇଛି ଚାର୍ଜ ସିଟ୍ ରୁ, କିନ୍ତୁ ରିପିଟେସନ ହବା ଯୋଗୁ ତାପରେ ସେ ଦେଖିଲା ବେଳକୁ ଏଇଟା ହଉଛି ପ୍ରକୃତରେ 36ଟା ୱିଟନେସ୍ ହଉଛନ୍ତି ରହୁଛନ୍ତି। ସେ 36ଟା ୱିଟନେସ୍ ରୁ 5ଟା ୱିଟନେସ୍ ଏକ୍ସାମିନ ହେଇଛନ୍ତି ଏପର୍ଯ୍ୟନ୍ତ।
No, Miller. That is reflected in the rejection order. That 10 witness has been examined on 21/2/23.
Rejection order?
Yes.
What is the rejection order dated?
Annexure 2, page 12. Relevant party, page 13.
ନାଇଁ ନା ସିଏ ଏଇଟା ହଉଛି ତାଙ୍କର ଆର୍ଗୁମେଣ୍ଟ କରୁଥିଲେ। This is not the finding of the court. This is the argument advanced by the learned counsel for the petitioner, but in fact it is not. In fact remains that 5 witnesses have been examined, and he has sent the deposition copy of those 5 witnesses, and 1 has shown hostile, 2 has seizure witness. So you get the, I am directing the registry to supply you those 5 deposition of copy. Are you having those copies of deposition, Mr. Rahul?
No, Millers, I am here to receive.
You collect it. I am directing the registry to supply it.
my lords.
And CD also.
And all land counsel for the state submit that he has not received the case diary along with the criminal antecedent. As per the order dated so and so, the London trial court has submitted the status report and also sent the deposition copies of 5 witnesses. Let the copies of deposition of those witnesses be supplied to the London counsel for the petitioners, who also London counsel for the state. Put up this matter. गोटे सप्ताह पर रख दो. Yes.
Item 16.
Only need 2 weeks time.
Item 16.
Only extension of time. 2 weeks time.
For surrendering.
Yes, ma'am.
The
16. 16.
15 withdrawn. एटा केबे डिस्पोज ऑफ हेतिला
22/9 में.
अच्छा मॉडिफिकेशन करिया 4 weeks टाइम दे दे हला फ्रॉम टुडे आई ए डिस्पोज्ड ऑफ. यस.
Item 17.
17 Mr. Rotho Gaurimon Rotho. What is this criminal appeal for?
OPD.
OPID.
Yes.
केते दिन डिले अछि कि नहीं? मिस्टर पात्रो
Popular district.
कॉपी कौन को कॉपी देना दी? अपील मेमो देना दी अपन को?
आगे
टोटल किछि कॉपी देना दी?
नहीं कॉपी
अच्छा नॉन appears for the appellant.
आगे
London Council, Mr. Patro, London Council, Special Counsel for the State of Orissa in OPID Act matter submits that the appeal memo, so also the annexures and the copy of the IA has not been supplied to him. Let the Land Council for the appellant supply the same to the Land Council for the state. Put up this matter, put a date the them. Yes, copy to be supplied.
Item 18.
Yes. Interim bail.
Interim bail report was called for.
Yes,
which is
Mr. Tripathi.
Yes, ma'am.
କାହାର କଣ ହେଇଛି?
Appellant man are suffering from stage 4 kidney failure man.
କାହାର?
Appellant.
ICU Medical College in critical condition, so and so, okay. देखिए कौन ଆସିଲା report देखिए. Writing of he was shifted to DHS Keonjhar, then shifted to SC Medical College, treated at SC Medical College from such and such day to return back to district jail, discharged from the SC. Acha. Then again shifted to so and so, treated at DHS, then referred to SC Medical College, shifted to so and so, was returned back to so and so, hospitalized in jail, taking medicines regularly as per the advice of the so and so. Health condition report is so. So, ଲୋକ କୋଉଠି କାର?
କେଉଁଝର.
କଣ offense କଣ?
Offense convicted 376(2) and 6 poster for 10 years.
IA number so and so. This is an application for interim bail on the ground of ailment of the petitioner, who is stated to be suffering from kidney problem and hospitalized in district headquarters hospital, Keonjhar, also SC Medical College Hospital. Medical documents have been annexed to the interim application. Land Council for the state has obtained instruction from the Superintendent District Jail Keonjhar in that respect, from which it also appears that about the ailment of the petitioner and his hospitalization. Considering the submission made by the learned counsel for the respective parties, the averments taken in the interim application, the medical document annexed thereto, and the report furnished by the learned counsel for the state, I am inclined to release the petitioner on interim bail for 2 months from the date of release. IA is disposed of, but a date they dewe, he will file the surrender certificate. Yes.
Obliged.
Item 19.
Yes, Mr. Mahapatro. May I please your lordship? What is this criminal appeal for?
Pardon, my lord.
Criminal appeal ta kon pai file କରିଛନ୍ତି?
My lord, in this present appeal, the appellant
Mic use କରନ୍ତୁ ଠିକ ସେ.
in the present appeal, appellant challenging the judgment passed by the learned first additional session judge cum special judge NDPS Barampur Ganjab.
It's a case of conviction.
Yes,
Yes.
What is the sentence imposed?
Conviction under section 10 years.
Page 43.
Operating part is
10 years, 1 lakh fine.
page number 43, my lord.
So what is the delay?
There is a delay of 7 days.
Just a minute. Yes, 7 days. Yes, Mr.
Yeah.
IA number so and so is an application for condonation of delay. Stamp reporter has pointed out that there is delay of 7 days in filing this criminal appeal. Considering the submission made by the land council for the appellant that it's a case of conviction and 10 years of substantive sentence has been imposed on the appellant, I'm inclined to condone the delay. Accordingly, delay is condoned. Hard admit, call for the trial court record. Interim applications for bail and sterilization of fine to be considered after receipt of the trial court report. Land counsel for the state shall obtain the custody certificate. Yes.
Deposition copy.
Deposition copy to be supplied to this.
Yes.
Delay condone. Admit. Yes. Next.
Item 20.
Yes, Mr. Panda.
Please, your there is a delay of 101 days.
What you are challenging here?
The statutory and order melodies passed by the OPID court.
OPID means kon order pass hitla.
Your lordship may see in the noting there is another number is there, CRLA 647 of 2022. Now in 647 of 2022, I had challenged an order of the OPID court refusing to release by way of interim measure certain bank accounts which had been frozen, my lords. Your lordship allowed that. And the judgment was delivered in my favor. After judgment was delivered, my lords, it was found, my lords, that 2 of the accounts, my lords, the numbers were erroneously given. For which, my lords, those 2 accounts could not be defreezed. So therefore, I filed a petition before the OPID court, and it was disposed of by annexure 1 to this appeal. That is in criminal appeal 23. Order dated 19/8/2023. The court writes, if your lordship will look at page 10.
No, that's on merit. We'll
Yes.
go through that. Yes, Mr.
Now, because this order was again appellable, but I could not file the appeal within time, and there is a delay of 101.
So what do you say with the delay condone, or you
take some instruction, my lord? Today I have received
IA number so and so there is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 106 days in filing this criminal appeal under section 13 of the OPID Act. Mr. Patral and Special Counsel appearing for the state of Odisha in OPID Act matter submits that he may be given some time to obtain instruction and if necessary to file objection to the interim application. କେବେ ରଖିବି କୁହନ୍ତୁ?
first week of February.
Okay, we release this matter in the week commencing from 5th of February 2020.
Lords, along with CRLA 647
ଆସିଛି ପରା? ନାଇଁ downloaded copies
record.
You want records? Acha, a code of this matter along with the records of CRLA number 647 of 2022. ପାସବୁକ୍ କଣ ଅଛି କି?